Right, Ms. Chair, the meeting is now live.
Thank you, Katie. As Vice Chair of SDAB, I call this March 3rd meeting of the Subdivision and Development Appeal Board to order. Today, unfortunately, our chair is unable to attend, and I am unable to act as chair for today's meeting. As a result, I'll ask, pursuant to Section 24 of the SDAB bylaw, for the members of the board to elect an alternate member to chair today's meeting. Are there any nominations to act as chair of today's meeting?
I'd like to nominate Jim Bell to chair.
Thank you. Jim Bell has been nominated to chair today's meeting. I move the board to accept this nomination. Those in favor, please raise their hands. Motion is carried unanimously. Thank you, Jim, for stepping in today.
Well, thank you, fellow board members, for the nomination, and happy to act as chair today. My name, as you now know, is Jim Bell. I'll be the chair of the meeting. All questions and comments shall be directed through the chair. I would now ask the board members to introduce themselves.
Hello,
I can go first.
Go ahead, Karen.
I can go first. Karen Mara, board member.
Peter Giraldo, board member.
Michelle Coos, board member.
Harry Scott, board member.
Thank you. The clerk for this hearing is Katie Bravo Stewart. Before introducing the appeal, I will now ask each member of the town's administration in attendance today to introduce themselves.
Good afternoon. I will start. My name is Eric Bjorgi, and I am the planning assistant with the town of Canmore.
Thank you.
I can go next. I am Marcus Henry. I'm the supervisor of the Planning and Development Department.
Hi, I'm Jolene Noel, meeting administrator.
Thank you all. Are there any additions, deletions, or changes to the agenda as provided? Hearing none, I move the board to adopt the agenda as circulated. Those in favor, please raise your hands. Motion is carried unanimously. Regarding the draft minutes for the hearing held on January 6, 2022, application number 202-10357, draft minutes were circulated to the clerk. Various board members have provided comments on the minutes to the clerk. Do any other board members have comments in addition to those that have been provided to the clerk? Hearing none, I move that the board approve the minutes of the appeal hearing of January 6, 2022, number 202-10357, as amended. Those in favor, please raise your hands. Motion is carried unanimously. I'd now like to introduce the appeal. The application number being appealed is PL 20210-394. I would now ask the appellant or their agent to identify themselves to the board.
Can we get the, do you want the video one?
This is start.
Yeah.
Sorry, there we go. Sorry about that.
Hello.
Hi.
Hi.
I'm Carmen Colburn. This is Greg Kleckie.
And we're actually representing a group of 13 homeowners on our block.
Okay, thank you. Does the appellant have any objection to any of the board members hearing this appeal?
No.
No.
Has the appellant received a copy of the agenda package distributed to the board? And do you have any objections to any of the information provided?
No.
Thank you. I would now ask the applicant or their agent to identify themselves to the board.
Good afternoon, Mr. Chairman. My name is Doreen Saunderson, and I am the applicant appearing in response to the appeal.
Does the applicant have any objection to any of the board members hearing this appeal?
No, sir.
Thank you. Has the applicant received a copy of the agenda package distributed to the board? And do you have any objections to any of the information provided?
Yes, I have received it. I have no objection to the material being circulated, although some of the statements in the appeal are inaccurate.
Thank you. I would now like to outline the hearing process. The process will be as follows. Administration makes a summary presentation of the matter before the board. Then questions of administration by the board. Appellant or their agent will speak in favor of the appeal. Questions of the appellant by the board. Those speaking in favor of the appeal and any correspondence in favor of the appeal. Questions of those speaking in favor of the appeal by the board. Applicant or their agent will speak in opposition to the appeal. Questions of the applicant by the board. Those speaking in opposition to the appeal and any correspondence in opposition to the appeal. Questions of those speaking in opposition of the appeal by the board. Those speaking neither in favor nor in opposition to the appeal and any related correspondence. Questions of those speaking neither in favor nor in opposition of the appeal by the board. The board may then ask for a short recess. Clarification of closing remarks from the appellant, then clarification of closing remarks from the applicant. Finally, clarification or closing remarks from town's staff. The purpose of this hearing is for the appellant and affected parties to provide the board with information to the appeal. The board must base its decision on planning merits. As outlined a moment ago, affected persons will be given an opportunity to speak. All speakers must ensure that all comments are directed to the board. Also, that all comments be of proper decorum and be succinct. If another person has already made a point, simply state that you agree with the point and continue. If any person presenting is referring to a written document, including a map, photographs, or a report, a copy of those documents must be left with the clerk. Once the board closes the public portion of the hearing and goes into camera, which is a private discussion, and will review all the information provided. The board will then provide a written decision within 15 days following this hearing. Does the appellant have any concerns with the process I've outlined?
No, we don't.
Thank you. Does the applicant have any concerns with the process as outlined?
No.
Thank you. I would now ask that the development officer make the presentation with respect to this appeal.
Good afternoon, members of the Subdivision and Development Appeals Board through the chair. Good afternoon to those in attendance virtually and those tuning in via our live stream. With the chair's permission, I have a presentation prepared. I will share with you now. So I'm here to present the Town Administration Report for PL 2021-0394, which is a development permit for the renewal of a bed and breakfast at 17 McDonald Place. This slide outlines the statutory requirements under the Municipal Government Act, including the posting of the decision, the timelines for appeal, the communication with appellant and applicants, and the notification of the appeal hearing itself. The statutory requirements are deemed to have been met in this case. To summarize the application we have before us today, it is a renewal of a bed and breakfast, which is considered an accessory use to a detached dwelling in the R1 district. It is a discretionary use in that district. The initial approval of this development occurred on October 2020, and that was by order of the Subdivision and Development Appeals Board. Under the land use bylaw, bed and breakfasts are initially approved for up to a term of up to 1 year, at which point a new development permit to renew that operation must be applied for, and those can be approved for terms of up to 3 years. We received public objections, neighborhood objections to the renewal of this development. And on close review by the planning department, despite the objections, it was determined to be compliant with the land use bylaw and was subsequently approved by the development officer on January 14th of 2022. And of course, we're here today as the neighboring residents have filed an appeal of this, of the renewal. So to orient ourselves on the property, this is an overhead view with the subject property, 17 McDonald Place, outlined in blue. And you'll note McDonald Place and Three Sisters Drive identified on the map. The zoning districts of this area, you'll see McDonald Place is within R1 residential detached district. We have an ED environmental district, green space to the northeast, and the R2 residential district on Three Sisters Drive directly adjacent to the southwest. And a view of the property from the street. So the background we need to be aware of when reviewing an application for a bed and breakfast renewal. We have the land use bylaw as our guiding regulations for bed and breakfasts, specifically the definition in section 13, the specific use regulations in section 8.3, the parking regulations in section 2.7, as well as the discretionary use criteria, as bed and breakfasts are discretionary use in this district. The municipal development plan provides us some policy guidance. There's one line on bed and breakfasts in the MDP saying that bed and breakfasts are supported as a commercial accommodation option for visitors, as well as a small business opportunity for residents. The Municipal Government Act provides guidance to municipalities, to development authorities, making decisions on discretionary use, speaking to their discretionary nature, that the development authority may permit these types of uses versus a permitted use, which shall be issued if it meets the relevant requirements. So getting into the proposal itself, I'm going to walk through the property and how it's laid out in relation to the land use bylaw requirements. So this is a detached dwelling. The main floor of the residence is occupied by the owners and operator of the bed and breakfast, whereas the bed and breakfast suites themselves occupy a portion of the basement of the dwelling. And I've circled a sign. You can't see it in detail on this photo, but this is a requirement of bed and breakfast, that they have a sign on the property that identifies it as a bed and breakfast. This is the overhead view, the site plan of the site. You'll see the parking is provided on the driveway, 4 stalls side by side. And technically we can count a 5th stall in the garage as the parking for the residents can be provided in tandem. So this is actually one stall in excess of what is required by the land use bylaw for on-site parking. The area in green is the landscaped portion of the property. This is another requirement that at least 50% of the site be landscaped. Sorry, 50% of the front yard be landscaped. The primary entrance to the dwelling is identified on the first red arrow to the right of the screen. There is access to the bed and breakfast suites through the primary entrance through an interior staircase, as well as if you follow the dashed line around the side of the building to the two rear arrows, two red arrows on the left, there are exterior private entrances to each of the bed and breakfast suites at those locations, as well as some amenity areas in the rear yard. Looking at the floor plan of the dwelling itself, this is the basement layout. This is highlighting one of two of the guest suites. So the interior staircase is the first red arrow, and following that arrow, you come to the entrance of the suite. There are two bedrooms, a bathroom, and a living area that includes what we call a wet bar, which it consists of a sink, a mini fridge, and a dishwasher. And the exterior entrance is highlighted in the red arrow at the very top of the screen. The second suite, guest suite in the basement, again following the red arrows through the interior staircase to the entrance. The second suite highlighted in blue. This is a 1-bedroom unit, so 2 units for a total of 3 bedrooms in the building. Again, private bathroom and a similar living, eating area with the same wet bar setup and an exterior entrance highlighted with red arrow as well. So starting to look at some of the bylaw conformance review of the development of these plans. Firstly, we look at the definition. Does what is being proposed, what is operated on the site, meet the definition of a bed and breakfast? So the land use bylaw tells us it is an ancillary commercial use operated by the permanent resident of the dwelling and providing a maximum accommodation of 3 guest rooms to a maximum of 6 persons for periods of 14 days or less. And we believe this operation does meet the definition of a bed and breakfast. This table you will find in attachment 3 in the report before you today. But this goes into detail of section 8.3 of the bylaw, which are the specific use regulations. I've already mentioned a number of them walking through the plans and the site layout. I won't get into each of them in detail right now, but suffice it to say there are no variances required or requested from these standards as part of this application. I would like to point out take the opportunity to point out an error in this table at the very bottom where the bicycle parking is mentioned. There is in fact only 1 bicycle parking stall for each guest suite required, not 2 as stated in this table. However, that doesn't affect the Schedule A that is attached to the report, the suggested conditions, as it's not specifically mentioned. There's just a general statement that the development shall be in conformance with the land use bylaw. So we received a number of neighborhood inquiries and concerns as a result of the proposed renewal of this application. And you have those in front of you today in the notice of appeal, and you'll hear more in person in their own words today as well. But I've summarized those concerns that were given to us at the time of approval. And I've laid them out in the report and on this page, and I'll just run through them very briefly to give you some context of how we see these concerns fitting in relation to the land use bylaw. And then after this slide, I'll go into some of the key points in a little more detail, but I'll just briefly run through them here. So we've heard about whether this operation is appropriate for the location. So the discretionary use criteria does ask us to look at this, this aspect of a discretionary use, and I will get into that. However, I'll note there's nothing to us that is unique about this location compared to other bed and breakfasts that have been approved across town. Second point is the owner operator utilizing a third-party assistance with some aspects of the bed and breakfast operation, and what that means for how we determine the operator and the principal resident requirements of the statutory declaration. And I'd note that there's no restriction in our land use bylaw on a bed and breakfast operator utilizing third-party support to run a bed and breakfast. The route of entry to the guest room, specifically the private accesses to those guest suites at the rear of the building. The land use bylaw tells us that guest rooms must be accessed through the principal dwelling and not solely through a private entrance. So it contemplates a dual option, a private access and access through the dwelling, in which case we've seen the floor plan is connected to the principal dwelling. The consumption of food within the guest areas. This is not regulated by the land use bylaw. The bylaw does talk about the presence of food preparation facilities, cooking appliances, but not the consumption of food. The frequency of the operator's presence at the property and guests being unsupervised. The level of presence of the operator at the site while they're having guest visits at their bed and breakfast is not specified in the land use bylaw. The guest rooms being self-contained suites rather than being integrated to the principal dwelling. Again, apart from requiring the suites to be connected to the principal dwelling, how self-contained they are above that is not something that's contemplated in the land use bylaw. The purpose and intent of a bed and breakfast not being met in the traditional sense that that residents might expect. Again, we can't go on what might be thought of as a traditional bed and breakfast. When we're looking at applications in front of us, we have to look at the definition and regulations as we see them in the land use bylaw. Traffic and right to quiet enjoyment. This is laid out in the specific use requirements for a bed and breakfast, that they cannot disturb the residents' right to quiet enjoyment of their residential neighborhood. And we'll talk about this in more detail in the following slides. So I'd like to talk in a little more detail about some of the key points that were raised in opposition to this development and how we interpret that as part of the land use bylaw. So one of the key issues we heard was the presence of the operator at the property while it's being rented and what that means for the operation and its impact to the neighborhood. So the operator has to sign a statutory declaration stating that they are the primary resident of the principal dwelling. And this ties them into the definition of a bed and breakfast, where the operator is the resident of the dwelling. So we take those statutory declarations at face value, and that is essentially our confirmation that the owner, the operator, is also the resident of the dwelling. The level of presence of the operator at the dwelling while it's being rented is something that's simply not specified in the land use bylaw. And I'd also point out that if we were to put some type of standard like that in place, it would be something that we would have to do across the board as a policy decision for all bed and breakfasts, and would also be something that's very difficult for the town to monitor and enforce would essentially require kind of surprise spot inspections, which would mean additional resources and a change in the way we look at bed and breakfast as a whole. The integration with the principal dwelling. So this is talking about the kind of dining and wet bar facilities, the eating of food within the suites, and the entry and exit. So many people might expect that a bed and breakfast, you are sharing meals with the owner, that there is that kind of interaction. And that may be the case in a lot of traditional operations. However, that is not required by the land use bylaw. Specifically, what is required is a connection from the suites to the principal dwelling, which we've seen is the case here. The floor plan is integrated and connected. There is no food preparation or cooking facilities in these units. There is mini fridges, sink, dishwasher, so guests can eat in their suites as long as they're not cooking within their suites. That's kind of the bottom line interpretation based on the requirements of the land use bylaw. And the entry and exit, yes, they have private accesses to their suites. Again, the level to which they use a private access versus they use the main access through the dwelling is something that is not specified. And again, would be something that would be very difficult for the town to monitor and enforce if it were a requirement. So looking at nuisance and offsite impacts, what is the impact of this operation to the neighborhood? So the discretionary use criteria in the land use bylaw does ask us to look at whether this development is appropriate for this location. And from what we can tell, there's nothing unique about this neighborhood, this street, that would make it inappropriate for a bed and breakfast when we look at the landscape of bed and breakfasts that have been approved across the town of Canmore. Distance from services was a point that was brought up. Again, we have no policy as to how far a bed and breakfast must be from the nearest commercial area, for example. And if this were something we would look at, it would be a larger policy discussion that we would have to look at for all bed and breakfasts, kind of beyond the scope of this single application. Traffic may be something that we would consider in a case like this. If we have a stressed on-street parking situation, something like that, we may think that, oh, this development may negatively impact an already tough situation. There's no evidence that that's the case on this street. We haven't heard that on-site parking is stressed in the area. We haven't heard that this development is causing a traffic problem. As we've seen, the development is actually exceeding their on-site parking requirements. What we have heard is that residents have noticed increased traffic, but there's no indication this is beyond what would be normally or reasonably expected from a residential property in a busy household, for example. Other types of nuisance and disturbance we might look at when we're considering impact to the neighborhood are things like noise complaints, disturbance complaints through bylaw services, and we're not aware of any of those types of complaints being lodged against this property or this development. So our administrative recommendation, we found in our analysis that this development does meet the requirements of the land use bylaw, and we approved it accordingly. We've included the conditions that we approved it under in attachment 5 of this report. Of course, this is in the SDAB's hands for consideration now, and their options are to to approve subject to the conditions that we've suggested, approve subject to alternate conditions as the SDAB considers necessary, refuse the application, or postpone pending submission of additional details. That concludes my presentation, and I'm happy to take any questions at this point.
Thank you very much for your presentation. At this time, I'd ask any of the other board members if they have questions for the development officer. Any questions? I have a couple of questions, if you don't mind. My first question is whether you considered section 8.3.0.14 of the land use bylaw in arriving at your decision.
Sorry, just give me 1 moment to pull that up.
If it helps, I'll just read it out so that everyone understands the question. It reads, at the discretion of the development authority, bed and breakfast developments may be permitted on the same site as a home occupation, where an applicant has adequately demonstrated that such an approval would result in negligible increase in noise, traffic, or parking on the property or in the neighborhood.
Yes. So I didn't touch on this in my presentation. However, it is in the report. And yes, that's a good point. There is a home occupation that is approved at this location as well. In this case, it's a home office for a consulting company operated by a resident of the dwelling. So it's a home office. There's no extra vehicles. There's no client visits or anything like that. In fact, it's a type of operation that doesn't require a development permit. It's just approved through a business license. So yes, in this case, we determined that to have a negligible impact to the neighborhood.
Thank you. My next question relates to the kitchen, or not kitchen facilities, but your analysis of the provision of the bylaw as to whether there are any cooking or food preparation facilities in the guest rooms. And my question is that the applicant's written submission, which we've received of February 23rd, 2022, also states that the units contain a kettle, coffee maker, and toaster. In your view, are any of these items cooking or food preparation facilities?
So something like a coffee maker and toaster, I suppose would be debatable. The interpretation that we've applied in the past is these kinds of convenience appliances where you couldn't prepare a full meal, for example, with a coffee maker and a toaster. That doesn't meet the threshold of being a cooking appliance for the intent of that section. Yes, that's my answer to it.
Okay, thank you very much. My next question on the same section of the bylaw, in the appellant's notice of appeal, they state, and I'll just quote it, TOC indicated in correspondence that without upper kitchen cabinets and 220-volt wiring, there could be no cooking and food preparation as prohibited by the bylaw. Can you please comment if that is a statement that the town planning department has made, and if you stand by that statement?
So you'll have to forgive me. I'm new with the planning department as of November. of last year. So I don't have the full background on previous correspondence. However, I know what that comment is referring to. That is looking at the definition of a kitchen in the land use bylaw. So there are certain aspects that define a kitchen in the land use bylaw. Those would be a full stove, upper cabinets, for example. So those, I believe the approach the town has taken is that if those elements are not included, the space is not a kitchen as defined by the land use bylaw, and therefore is considered not to be a cooking or food preparation space for the purpose of a bed and breakfast.
Okay, thank you very much. I have one final question. Sorry, I have two more questions. Just would appreciate it if you could clarify what you mean when you say that there is no sound evidence that the level of traffic is beyond what would reasonably be expected in a residential area. You've commented that you're of the view that there was no additional traffic beyond what would be expected from a busy household. Can you just please provide additional clarification on that comment?
Sure. So when we're looking at traffic that results from a development, really without a professional traffic study, we can't say what the exact levels of traffic resulting from this development are. However, the interpretation that we're taking is that this bed and breakfast requires 2 parking stalls, for example. It's not beyond reason to think that a household with a number of teenage age kids, for example, who all have cars, you may have 3 or 4 vehicles associated with a household, a normal residential household, without any accessory or discretionary uses such as bed and breakfast. So in this case, this household and the associated business does not appear to have parking requirements or traffic levels that would be above other conceivable residential examples.
Okay, thank you for that clarification. Finally, I have a question on your proposed Schedule A conditions of approval. Specifically, the wording in specific condition 1 seems to be somewhat different than what the SDAB ordered in November 27, 2020. The difference being the use of accommodation rooms versus suites. And I'd appreciate if you could comment on that.
Sure. So we did make the change of the terminology from suites to accommodation units. And that was just to better align with some of the wording that's in the land use bylaw, specifically in the parking section. It talks about accommodation units rather than suites. So the intent is the same. There's 2 suites or accommodation units, however you want to define that, with a total of 3 bedrooms, but the intent is the same.
Okay, thank you. I have no further questions. Okay, I would now ask the appellant to make their presentation with respect to the appeal.
One of the
Please.
board members had a question there.
Oh, sorry, I missed that. Sorry.
No
Ms.
problem. I
Maher,
had.
sorry about that.
No problem. I'd like to ask a question through the chair, if I may.
Yes.
It was just following up on a little continuation of your question regarding cooking facilities. When you look at approving a unit, are you looking at only on the interior, or are you also looking on the exterior for cooking facilities?
Thank you for the question through the chair. Our interpretation is that the requirement in the land use bylaw, the prohibition of cooking facilities, applies to the guest rooms proper. We don't look at the exterior of the building, the amenity spaces, whether they have access to exterior amenities. We haven't taken that interpretation in the past. We've focused on the interior of the dwelling unit.
Thank you.
Chair recognizes Ms. Coos.
Thank you, Mr. Bell. I'd like to touch on the question of kitchen a little further. And specifically, I want to distinguish or get your help in distinguishing between a dwelling unit definition and kitchen and the section 8.3 bed and breakfast language, which says no cooking or food preparation facilities. Bringing your attention first to the dwelling unit definition, it says that it looks as though a kitchen is, due to its design, plumbing, equipment, and furnishings, may be used primarily as a kitchen. And then it has a brief list of examples, but then also says other aspects which may define a kitchen. So I would just like to know, first of all, does the town of Canmore have any guidelines or policies relating to definition of a kitchen or a food prep facility outside of these two documents? Anything formal?
No. Through the chair, what we're relying on for guidance in this case is the clause in section 3 as it applies specifically to bed and breakfasts. This is what we rely on primarily, and this talks about food preparation and cooking facilities specifically. Now the requirement on the kitchen, that is more in the realm of the dwelling unit approval. There are limitations on, for example, how many kitchens you can have in a dwelling unit. So I think we have the two crossover, of course, because these bed and breakfasts are contained within the dwelling unit. So we want to doubly make sure that the space is not a second kitchen under the definition of a kitchen. And secondly, that it meets the specific requirements for bed and use relating to cooking and food preparation facilities.
So if I may further question through the chair, ask what other aspects could, in your opinion or the opinion of the planning department, define a kitchen other than 220 volt electricity in a full size fridge and upper cupboards? What kind of plumbing, space, furnishings would you typically consider a kitchen or a dwelling unit?
Sure. Since this isn't specified in the bylaw, we're relying on interpretation and kind of past precedent in, when we're talking about how developments are handled in general. But in my experience, the key component is always some kind of cooking appliance. This is generally what distinguishes a kitchen from another space. So, we basically draw the line, if I can give a clear example, at a microwave. You can prepare many meals, microwave meals, with that type of appliance. So, at kind of the bottom threshold of what we would consider equipment that would make a space a kitchen, it could be something as small as a microwave. But without Without a cooking appliance of some kind, our stance would be it is not a kitchen.
Thank you.
Are there any other questions from the board for the development officer? Okay, hearing none then, I would ask the appellants to make their presentation with respect to their appeal.
I'm just gonna get our slide deck up here.
Okay.
Yep.
Hello, I'm Carmen Colburn. This is my husband, Greg Klecki. We live at 10 McDonald Place, directly across from the subject property. As part of our presentation today, we did prepare a few slides, not as fancy as Eric's, but they'll have to do for today. The first I want to show you is a visual of the homeowners in our neighborhood who have submitted their objection to the application for this development permit. The yellow is the development property. The red circles represent all of the homeowners who have expressed their objection. Some of them will speak to you today. Some are just listening in, some are at work. But we brought this appeal to you today to make the case that the planning department reached the wrong conclusion when it reviewed this development application. We know they thought hard about the questions it raised and the issues they were facing, and their decisions were made in good faith, we have no doubt. Nevertheless, we believe strongly that the decision to approve was wrong. In the staff report and presentation, the planning department says the concerns raised by us in our objection to the renewal were, quote, matters that are either not regulated or specified within the land use bylaw, end quote. We will argue to this board that the current land use bylaw, while it's not perfect, did indeed contain adequate regulation and specificity to deal with our objections. So with that, let's start our discussion. First of all, we believe that the discretion that was available under the land use bylaw was applied contrary or without due weight to the prior decisions and directions of council. What do I mean by that? Canmore was not immune to the rise of hotel alternative short-term rentals offered under VRBO and Airbnb. But our councils of the day were proactive in facing the issue. They weighed the benefits and the impacts, and they decided heavily in favor of protecting residential neighborhoods from the negative impacts of short-term rentals. As a result of their vision, short-term rentals are prohibited outside commercial districts. Tourist homes are prohibited except in a few limited places. And bed and breakfast within residential zones remain very limited. And even then, allowed only if the operation is not disruptive to the neighbors. As we will show you in our presentation, the operation at 17 McDonald Place is a short-term rental of 2 self-contained suites, each with a kitchenette and barbecue instead of a kitchen. There is really no other meaningful distinction between these suites and the short-term rentals that Canmore has already decided to prohibit in R1 districts. And the reason short-term rentals were prohibited in residential neighborhoods like ours was because of their negative impacts. Living in such close proximity to this development, we witnessed firsthand the negative impact of the rentals at 17 McDonald Place. Throughout the initial permit year, we identified 3 issues that were particularly troubling. You will see a striking similarity to the issues that caused the town to prohibit short-term rentals in the first place. What are these 3? The first is resident safety. Obvious, it's of great importance. It was fundamental to the decision to prohibit short-term rentals within residential neighborhoods. In our case, without exception, every day of the year, there are at least 2 cars full of complete strangers in 2s or 4s, sometimes more, who arrive and depart from multiple car and taxi trips at all hours of the day and night. Any neighborhood would find this disturbing. In our case, we have 5 single women living here. It has had an effect. The second negative impact was, like any new development, this one generates additional traffic. But due to the poor location of the rentals on a one-way in, one-way out cul-de-sac, the excessive traffic is unavoidable and impactful. We estimate just one trip into town by each guest each day generates as much as 35% additional traffic on our small street. Why is that so high here? Because a sizable majority of our residents are at home, mostly retired. They do not travel into work and back each day. They don't have teenagers driving back and forth each day. So the extra traffic from these guests adds up quickly and affects our privacy, our sense of security, and raises the fear of accidents. Obviously, to anyone looking at it, this street is a poor location for visitor rentals. There, see the narrow lane. There's no sidewalks. We have scattered looking parking that creates lots of blind spots. When you live up here, you know to exercise extra caution when you're driving, especially at night. If you're a stranger, you have no idea. And because we have no public transportation anywhere on the hill, it means every time a visitor wishes to access amenities, it's almost entirely by car, which means additional trips in and out. Not only is that affecting our neighborhood, it is clearly contrary to the town's investment in our downtown tourist infrastructure, not to mention the shared vision we're trying to incorporate and realize in terms of building a sustainable non-vehicle-based community. And finally, the demand to keep short-term rentals in the commercial core was because of the overwhelming need for potential suites to be used for permanent resident housing. As the planning department reviewed the application for 17 McDonald Place, it should have been informed by all the discussions the broad community has already had about tourism rentals and why they need to be restricted to commercial areas. Our own community advised the planners of our concerns early on, and these well-known impacts should have weighed more heavily against the developer's request for approval of each of the aspects of their plans. So given this background, we turn to the specific bylaws we feel were incorrectly applied on this particular development file. And each of these presents an opportunity for you on this board to reach a different conclusion. The three requirements that we're talking about for approval of a B&B under the land use bylaw that require discretionary interpretation of specific language start with the first one, access. 8.3.011C. I'll give you a moment just to read this simple language. It says, a bed and breakfast development shall provide access to the guest bedrooms through the principal dwelling unit and not solely through a separate private entrance. I interpret this, and everybody I've ever spoken to interprets this to clearly say that when a guest arrives, they enter their guest bedrooms through the principal dwelling unit. This was interpreted exactly the same way by the Subdivision Appeal Board last year when they asked exactly the same question. How will the guests enter the suites? And were told by the owners they would be greeted and would enter through the front door of the dwelling unit. And the same sentence says, they shall not enter solely through a separate private entrance, which is exactly what occurs in this development 100% of the time. By observation among our neighbors, many of whom were home under the COVID limitations and otherwise have a hard time not observing this property all day long, we can confirm no one has ever seen a rental guest be greeted and admitted to the home through the front door. And there have been a lot of rental guests. As further evidence of what actually goes on when the tourist guests arrive, we point you to the check-in instruction the developer submitted with her package. It's attachment D. It's on your page 55. We have the text of it on a slide, a series of slides actually. So can you go to how to find your unit? These are the instructions that the management company in Calgary has sent to the rental guest. When you arrive at your property, you can park. You walk around the left side down to the backyard area. You will find 2 suites. Once you're in front of the front door, just enter the code. Moving on, the resident owners and operators, Doreen and Dale, who live upstairs, will be happy to greet and assist you if they are home and available. However, it is not necessary for you to contact them, and you may enter and exit the suite through your private entrance in the back anytime during your stay. So you recall the words, this development is expected to provide access to guest bedrooms through the principal dwelling unit. The instructions to the renters do not include an expectation being met by the owners and entering their bedrooms through the home. Of course they don't. They don't expect it. They have no idea this is supposed to be a bed and breakfast experience. For them, the B&B is just a sign they see on the front of the property when they get here. As far as they know, it's a condo they rented on Airbnb for their Canmore vacation. And we submit to you that the physical layout of the suites makes it pretty obvious that any access through the home that might occur would be an exception and not at all the rule, regardless of any bylaw or regulation presented to these homeowners. So when faced with this information, we believe the discretion of the planners should have been applied to find that the guest bedrooms in this particular physical layout would not be accessed primarily through the dwelling unit, as required by a common sense reading of the words 83011C. And we ask the board to substitute your decision on this issue and find that requirement is not met. The next bylaw discretionary decision, I'll give you a moment again, although we have talked about it already quite a bit. Basically says neither food facilities nor food preparation facilities are to be located within a bed and breakfast bedroom or suite. The planning department applies their discretion to say this means only a full kitchen is prohibited. But this is completely arbitrary. The specific wording of the bylaw is much more precise. It prohibits cooking, yes, but then it prohibits all food preparation facilities. Food preparation, not cooking. This is clear common language. If a full kitchen or cooking had been the only limitation, the prohibition could have simply said that no kitchen shall be located, or even no cooking facility shall be located, but it didn't. It said no food preparation facilities. And the evidence before you in this file shows that there are mini kitchenettes in each of these suites. There's a counter, and a little fridge, sink, and cutlery and dishes, and toaster and kettle. We believe there is a barbecue on the outside too, but they say that they don't include that, although I suppose that's another arbitrary decision. We believe there's no need to say this should only apply to prohibit full kitchens. That interpretation has migrated over from this discussion of when is a suite an illegal suite. But this is a different context. This is in the context of the bed and breakfast bylaw that is overseeing a short-term visitor business. They are not at all similar, and the reason for them to exist is not at all similar. Had the planners applied the words of 83011B with greater specificity, the permit could have been denied on the basis that the suites did not conform to the clear wording of this section of the bylaw. The third exercise of discretion we believe was incorrectly applied relates to the notion of being an operator of the business. In two places, the term is used in conjunction with bed and breakfast development. In both places, the bylaw seeks to ensure the principal resident and the operator for that bed and breakfast are one and the same. Under Section 8, the operator of a bed and breakfast must declare they are the principal resident of the dwelling. And under Section 11, a bed and breakfast must be operated by the permanent resident of the dwelling. Whether someone should be considered the operator of a business is a question of fact, not just a declaration. And we say the way to answer that question is to ask, is the homeowner, sufficiently involved in the business to meet the plain language meaning of being the operator of the business? The homeowner of 17 McDonald Place declares she is the operator. We submit this is simply not true. The operator is actually a vacation rental company in Calgary. Let's look at how many of the key elements of the business are handled by them. We refer back to the instructions each guest receives from the management company After the management company has already taken the inquiry, checked and confirmed if rooms are available, discusses and then takes the booking, secures the rental payment, and sends out the details surrounding the renter's stay, including access instructions we looked at earlier. So back to this, let's go back to those instructions. We note that for the continental breakfast, the renters are to place their food order online. Later on, I, meaning the host manager at the company, says she will inform their cleaner how many guests to expect, so that towels and food for just that many will be in the condo for them. And who is enforcing this guest limit if additional guests show up? Well, it says the city of Canmore with a $500 fine. We know the city of Canmore is not enforcing this at all. So when a reservation is made for 2, how do we know that 6 or 8 renters don't show up? And how do we know that the guests who actually registered are the ones who do show up? This goes back to the safety issue we talked about earlier when we said we have complete strangers in our neighborhood. We've already discussed arrival, pointing out again, with guests having no expectation of meeting the owners who live upstairs, who may be able to assist if they're home, but that there's no need to contact them. And if they have food delivered, make sure the driver knows to go around the back, bag up your own garbage and dispose of it on your way out. As for checkout, lock the door behind you. Thanks for treating the condo with respect, and message me anytime if there's something you can't figure out. How could anyone look at this operation and conclude that the applicant is operating this business in anything more than just as a label? There is no expectation she will have any engagement with these guests, and I put that in quotes because these are not guests, they're vacation renters. Are they managing the marketing, doing the reservations, handling payments, managing check-in and check-out, cleaning, laundry, or really providing any guest services at all? These are the functions of operating this business. It is not simply a reasonable conclusion that this operator is actually operating a business because it is not a bed and breakfast business. It's a vacation rental business, and it's being operated by a firm that specializes in vacation rentals. And claiming to oversee the business is not operating it. That is the function of an owner. In this case, one who provided 2 revenue-generating assets, being the 2 suites, for a company in Calgary to operate that company's rental business and provide a return on those assets for this owner. We do not see that as a reasonable interpretation of operating a business. After months of personal observation among our neighborhood, we let the planning department know that the rental business continues to operate at essentially 100% occupancy without interruption, whether the homeowners are in residence or on holiday, simply away for a day or 2 or a week or 2, or, well, you get the idea. It makes no difference whatsoever whether they are there or not. So again, we ask, who is the real operator? For many reasons of community importance, including bringing a halt to any future proliferation of these rental businesses, we hope this appeal body disagrees with the planners about the level of engagement required of an operator of a B&B. Subcontracting out all of the effort means the owner can be away an indeterminate amount of time. Does this mean we will have B&Bs in Canmore that can be operated by weekend residents, so long as they claim they're the principal residents of the dwelling unit? As more and more of us are semi or fully retired, is this an easy income source that does not limit our travel and vacation plans? A reasonable interpretation of the facts could have led the planning department to conclude the level of engagement by this applicant in this application does not meet the minimum threshold of being the operator of this business. Under any common sense understanding of the word, a term does not need to be defined in a statute to have a reasonable meaning attributed to it. And in this case, there's hardly even a gray area once the facts are presented. Finally, if there is disagreement on the facts, when there's contrary evidence, such as she said or they said, so that an absolute conclusion is not reachable, the application of discretion should have been applied in favor of the neighbors and not the developer making the request. And had the discretion been applied to find the applicant could not reasonably have been found to be the business operator, the permit would have been denied on that basis. And we ask this board to consider substituting your reasonable definition of the operator of a business so that this manner of bed and breakfast management is not permitted within our community. So above, we have reviewed 3 sections of the bylaw that lead to, we believe, could have led to a different outcome. What we're going to ask now is to look at a section of the bylaw that is not really a discretionary consideration. It's the question of quiet enjoyment. It's the question of what is the fundamental character of a residential neighborhood that the prior councils weighed so heavily in deciding to prohibit short-term rentals from being located here. We believe the bylaw itself tells us what that fundamental character was supposed to be. It is the right of residents to quiet enjoyment of their residential neighborhood. It's contained in the bylaw about the bed and breakfast. It's specific to the bed and breakfast. It shall not interfere with the rights of the residents. It's unlike the other land use bylaw sections that we talked about. Those have room for discretionary interpretation. This does not. It's not conditional. It's not subject to debate. The prohibition is absolute. It shall not interfere. It's undoubtedly true. Each resident is going to have a different description of what interferes with their quiet enjoyment. You'll hear from a bunch of us kind of detailing some of those things. In our personal case, though, for Greg and I, we've lived on this cul-de-sac for 33 years. Never once have we heard of a complaint raised amongst our neighbors until this. When residents in a home are your neighbors, you get to know them and understand them. You live your life, but you go out of your way to avoid letting your life affect other neighbors' lives. We believe quiet enjoyment comes from living in an authentic residential neighborhood. And it should not be surprising that if a bed and breakfast is operated like a vacation rental, it will create the same kind of negative impacts, and the surrounding neighbors will end up objecting to the same disruptions. And that is why we are here today. The planning department told us we need to prove our quiet enjoyment is affected by showing objective measurements like increased traffic counts or noise complaints. We think this is wrong. A large majority of our neighbors told the planning department that this development interfered with their quiet enjoyment. There is no substantive measure that can replace the objective statements of such a large percentage of a neighborhood. It's a cumulative expression by the residents that should have mattered far more than a missing traffic count or noise complaint left on an after-hours bylaw enforcement phone line. The result of not fully appreciating our statements was that the planning department felt able to stretch their discretion at multiple points in a way that resulted in approving a development that stretches every limit of the land use bylaw, that pushes discretionary decisions into implausible interpretations of common language, greatly affects our own residential enjoyment, and opens the door for proliferation of otherwise illegal short-term rentals. We hope the Subdivision Appeal Board finds this an unacceptable result for our neighborhood and for our community. I'm going to have some of the 3 other residents of McDonald Place add their voice to flesh out the portion of quiet enjoyment. But before I turn over that presentation, please give me a brief moment to address a mischaracterization of our community that was made by the applicant. Her description of the events of the past year and a half makes it seem as if there was one disgruntled neighbor from the beginning who had always opposed the B&B she and her husband Dale planned to operate. Both of these statements are false. At no time did I or the neighbors I spoke with object to a traditional bed and breakfast. We simply did not believe that the layout of the suites could be conducive to such an operation. And we noted both homeowners were professionals with active business interests, including in the city. And taken together, we did not see how their plans could align with the hosting and unique visitor experience that's expected at a bed and breakfast. As it turns out, we were right, although it took many months to figure out what kind of business it actually was. On the other point, throughout the year-plus discussion of this business, I spoke on behalf of multiple neighbors, expressing their concerns, asking their questions, and communicating answers that I received from the planners. The planning department knows this is the case, as they were advised of it in our many communications. I was not speaking as a solely disgruntled neighbor. I was trying to figure out how the operation we were observing could possibly have been allowed after the well-known prohibition on short-term rentals in Canward's R1 neighborhoods. Not everyone is comfortable digging into technical language in a statute or a bylaw. Because I've volunteered for many years on committees of this town, including this one as a vice chair back in dinosaur days when I had my own business, I was willing to bring forward our questions and report back to our neighbors. If the only problems with this development were problems Greg and I had, we would not have bothered all of you. But our concerns are shared by our neighbors, and they have been since the beginning. And with that, I wonder if Jerry Auld is available to add his comments.
Yep.
Thank you, Jerry.
Just one moment, Mr. Chair.
Yes.
Just with the meeting procedures, we'll have to follow those procedures. So right now, I think now that the appellants have had a chance to present, I believe the next in line would be the applicant, and then any public, anyone of the public that wishes to speak would be after the applicant.
The people that want to speak are part of the applicants, or part of the appellants rather, and they're not just observers. So they're part
They
of.
are part of the presentation that we were
Appeal.
making. And I think we asked you this question when we were preparing, whether everybody had to send in $250 for a separate appeal, or they could speak as part of the presentation of a single appeal. And so there are 3 who are planning to do that as part of our main appeal, not as just an extra voice.
I believe that at this point, since the appellant has made their presentation, we would then have questions from the board to the appellant. After those questions have been posed and answered, then I would basically ask anyone else who wants to speak to the board in favor to leave their name with the clerk. And after the others have spoken in favor, then the applicant would make its presentation.
May I make one comment? If that is how we're going to have to proceed, I would like the board to know that the 3 other people who were planning to be part of the principal presentation, this presentation, were all speaking, well, they may have other things, but they were going to speak specifically to the elements of quiet enjoyment that have been, their quiet enjoyment that have been disrupted by this operation. So it is a really fundamental part of our presentation. And if they can't speak now, if they could just hold that, knowing that there is more information on that particular point that will be coming, new information, not just, because I have taken that out of our main presentation and it was to be presented by them. So if you could, the board could keep that in your minds if they're unable to speak now.
Well, I think the way I would like to proceed is, at this point in time, board members will pose questions to you as the appellants. And after we've done that, then the other 3 who wish to speak on the issue of quiet enjoyment, they can speak and we can ask them questions. And if there's a, does that make, are there any objections from anyone to that process? Okay, so at this point, then I would ask any of the other board members if they have questions for the appellants. Chair recognizes Mr. Giraldo. Sorry.
Thank you, Mr. Chair. I have a question regarding safety. You've expressed concerns regarding the safety in the neighborhood. I'm just wondering if there have been any instances where your safety has been threatened objectively rather than a subjective feeling of not being safe.
I can't say that I have, other than, I mean, we have had some confrontational instances, and yes, as a result of those, there's a number of us who don't feel particularly safe or at ease on our street. But as far as a break-in or something like that, I can't say that we have. There have been a couple of instances of people going way too fast in their cars as they come around the corner and whatever, but occasionally someone has gone out and told them, you know, to be more cautious and more careful. So I'm just telling you my personal experience, how I feel about it, but the others may have different, you know, alternatives.
Some of it's just unease as well. I mean, example of there's a no smoking policy, so people that want to smoke are out on the street and walking around and kind of skulking around, and you know, when it was really dry, throwing their butts around, and then that creates a bit of a confrontation. So it is more of an unease from a man's perspective, and from a female, like Carmen said, there's a number of single women around here, and just having so many strangers in the neighborhood and walking around, I think it's fair that that is intimidating.
Thank you.
Are there any other questions? I have a couple of questions, if I may. First one is just if you would please help me and the other board members understand how the various signature pages with signatures from supporting, from neighbors supporting your appeal, how they actually relate to the notice of appeal. And I'll tell you why I have a question. They seem to all be dated in November and attached to a petition. And your notice of appeal says that you're making the appeal on your own behalf and on behalf of these other neighbors that have signed. Can you just please explain to me the time sequence of that and whether these neighbors have somehow confirmed that they actually support the appeal?
Yes, I can. Instead of getting signatures done all over again, I simply sent the emails out to each of those people and said, here's the draft, like here's the draft of the appeal that will form. And are you comfortable? I think it was in the objection. Are you comfortable with remaining on it? Are you fine with having your name associated with it? Shall I use this? And I'll just use your existing appeal. So yes, I have confirming emails for all of that. And one extra that has now become full confirming that had previously done on his own.
Okay, thank you. And were those confirming emails supplied to the clerk?
No, but I certainly can. And one phone call, but yes.
I think that would be important evidence to have supplied to the clerk.
Okay.
If you would, please.
Go ahead.
My next question is, you gave a comprehensive presentation on the operator issue in your mind, and I'm just wondering if you are aware of any case law that could help the board in understanding what operator means in this context.
No, I raised this. I was back and forth with mainly Marcus all of last year on all the points around this. So, but operator was one that kind of came to me later in the year as just for various reasons. And I talked to him about that, or we communicated a bit about that. And I'm not sure it had been raised in this context as something that needed to have a more thorough analysis or thinking about what that word meant in this context. So I'm not sure, at least in Canmore, that it's come up as something for this level of consideration. Perhaps the issue hasn't come up at all, or the question hasn't been asked previously.
But I think in business, that an operator is typically the one where the individual has some hands-on involvement in the business, and as opposed to an owner or somebody who's a director or whatever. An operator is somebody who's involved in the day-to-day operations. I think that's kind of just a well-known fact in the business world anyway.
But the one thing I did raise with Marcus in an email earlier this year was that the town of Banff had, undertook spent a bunch of time. They're dealing with this from a different perspective. I get that. But that they did identify a list of, characteristic tasks, if you will, that would be involved in the day-to-day operation of a bed and breakfast. And so that informed some of what we talked about here. Is okay, well, yes, they broke it all down, and that was quite helpful to have that list and then to compare that against this. And I think I made a reference in our written submission, and I certainly had a lengthy submission to Marcus, pointing to that as something that we could have, or they could have had reference to in kind of looking at what is an operator in a bed and breakfast context.
Okay, thank you. In a similar vein, again, to help the board, are you aware of any case law, either from this SDAB prior decisions or other SDABs or courts in Alberta that interpret the words facilities and equipment and suites that are prohibited, the cooking or food preparation facilities?
No, I'll answer the question. I did not, but I will also be honest. I can't say I looked. I seriously, operator, yes, we did look and kind of got some better sense, but food preparation, I must say I did not.
Okay. Thank you. That's all of the questions that I have.
Yeah.
And any other questions, follow-up questions from board members? Peter.
Thank you. I have a question, just trying to understand your argument regarding operator. I've read the list. I see that it has a number of things: cleaning, changing over the linens, etc. Is it your position, or the inference that I'm making about your position is that an operator cannot contract out those roles and maintain their operator status? Is that the position that you're taking?
I would say no, not at all. If you're operating a bed and breakfast and you're doing the full range of responsibilities, I mean, I think it would be really, make common sense to perhaps take the cleaning out, to have the laundry sent out and have that done offside or outside of the home. I think a number of things can be, but it's kind of like the cumulative of it. Really, the core of running a bed and breakfast, not that I've run a bed and breakfast, but I have had some experience in short-term rentals. The core of that business is in the reservations management. It's in the communications, the setup, the finding the room, availability to match the request, getting the deposit, confirming, that's a really significant part. In terms of our own experience staying in bed and breakfast, which is something we love to do, the difference for us between a rental, like I'm talking about, and it's the hosting component. It's the meeting and the greeting and meeting the other guests and being made welcome in that part, whether it's in the home or, in a common lounge area that the bedrooms add on to. So, that is also time consuming, there's no doubt. But I don't say that you can't, that you couldn't possibly outsource some of the more mundane issues, but the really core issues,
But if the business can run without you for weeks on end, up to a month, which we've witnessed, then to me, that's not an operator. Like if you don't need to be there and you don't even need to have any contact, that's not an operator. I don't know how you want to slice it, but to me, that's pretty clear.
Thank you.
Are there any other questions for the appellants? Okay, at this time, then I would ask others speaking in favor, and I understand there are three, to come forward, provided that they have provided. Oh, there are four.
Yep.
Okay, provided that they have registered with the clerk in advance.
Yes.
Yeah. I would, if it's possible, I'd like Jerry to start. Jerry Auld, are you still on?
Yeah, I'm here. Thank
Great.
you.
Hey.
Carmen, thank you very much. Hi, everyone. So I assume everybody can hear me fine. all that. My property is a bit different from everybody else's on McDonald Place. I live down on Three Sisters Drive. So instead of seeing the front of the property with traffic issues, my backyard, South Point, adjoins the north point of the B&B's backyard. More to the point, my window, because we're on a bit of a hill, so my house is a little bit lower than theirs. Our bedroom windows are directly across from, are in an angle from the two patios of the bed and breakfast. So our bedrooms are no more than 20 to 25 meters away from those patios. The issue that we have with quiet enjoyment is that when the operator is or the homeowners are not there, we quite often have guests that stay out late on the patios, talking, drinking, playing music till quite late. This is after the 11 o'clock, where we would assume everybody has the right to enjoyment of their backyards. This is into 12 o'clock, 1 o'clock. We tried calling Bylaw at the start, but that doesn't work. It just goes to a answering machine, and then the next day, by the time Bylaw picks that up and gets around their rounds, the guests have left. And so the purpose, I think, of Bylaw and long term to make complaints and all that is to change behavior over the medium to long term. But this is short term, so we may get a change of behavior if they're staying 2 nights, but usually they don't. And the next group, it's net new. Suddenly we're starting again. So we just stopped calling because it doesn't do anything for us. As my wife keeps saying to us, it's like the people who are staying there know if the homeowners are there or not. It's like teenagers partying when the parents aren't home. And so we see this quite often, especially in the summer when it's hot out. We need our windows open to vent and get fresh air in. And that's our biggest concern about it. If the homeowner was there, we never see this problem from a noise standpoint. That's it for me.
Thank you very much. Next speaker in favor.
Sully, are you on?
Sully? Maybe go to Louise.
Sully, are you there? We may be muted. I don't know.
Can we see him?
I don't know. Do we see him? Just hold on here. I don't actually see him right now. Let's hope he'll come back. Brian?
Yeah. Can you hear me?
Yeah, we can. Hi, Brian.
There he is.
Hello.
I look so haggard. I just got back from a crazy bike ride. I'm sorry, guys. I guess, can everyone hear me? That's good.
We can hear fine, thank you.
Okay. My biggest issue, I live in 13 McDonald Place, in sort of the end of the cul-de-sac from the bed and breakfast. Sorry, I'd like to call it an Airbnb. And the thing about it, that at first I was not really against it because I thought it was a B&B, because my impression of an B&B was is just that you're like a family hosting people, giving them a room to sleep, and there's some participation with the homeowners where you knock on their door and they invite you into your home and you get a breakfast, perhaps you eat together kind of thing. And so I was like fine with it, but then in practice, and I know you guys have gone through all the legality here and stuff, but I'll just mention that the spirit of it is just not a B&B. It's an Airbnb. It's advertised as such on their website. It's on the Airbnb website. It's hosted by other people. So it's not even like you have this impression that it's a couple from Canmore. It's someone from Calgary. And so if it looks like an Airbnb, it's on Airbnb. It smells like an Airbnb. And I use Airbnb, and I don't see any distinction at all. It's not a bed and breakfast, it's an Airbnb. There's separate entrances. The owners don't have to be there. To me, it's just it's sidestepping stuff, and it creates acrimony with the neighbors. So looking at the people opposing this, it's like you're surrounded, all your neighbors are surrounded by this, don't want it. And that's affecting our neighborhood. And I don't really appreciate that. It makes it so that, you know, I purchased an R1 lot, and under the impression that we're out of the zones of Airbnbs, and my enjoyment of my property, where someone's coming in every single day, 2 different groups of people are coming in every single day to my street, strangers every day, and then a new group comes in every day, and it just, like, the spirit of a B&B, it's not happening. So to me, it seems extremely unfair that people like that can run an Airbnb, but no one else can, and if you skirt the rules here and there. So I don't think it's fair, and I don't like having strangers come to our street on a constant basis. It's affecting the enjoyment of my property. So, like, and also, like I said, having this acrimony between all these neighbors, they don't want it. Why would you guys allow this to happen? It's just, it seems unfair to me, but that's what I got to say.
Thank you, Brian.
Thanks, Robert.
I'm going to unmute myself now.
Mr. Giraldo,
Chairman.
please go ahead.
Sorry, I have a question for you, Brian, about the operation. You're saying that your concerns are that it's operating like an Airbnb. Were it operating like a bed and breakfast with the same amount of traffic, with the same number of people coming day in and day out, but Doreen was meeting these people at the door, would that change your position? Would you still maintain that the impact is negative?
I would have to say that it would, like there's obviously some give and take where we live in a community, and I would say that that it would be a lot better managed if you had to go through if you had to knock on their door to host people. Not to mention that there's 2 separate units, so it's like it's a business being run, but I would agree that it would be a bit better for it to be run more in the spirit of a B&B, where there's, you don't have codes for doors that you can just come and go as you please. It's you don't go onto Airbnb, the app, and deal with someone else to sorry, my phone blipped out. So I would say that it would be better for it to be run a little bit more like what my impression of an B&B is versus an Airbnb.
Thank you.
Does the board have any other questions for Mr. Cook? Okay, thank you. Then the next speaker in favor of the appeal.
Are you there, Kathy? Unmuted. Kathy?
You're unmuted.
Oh. Are you there, Kathy and Sully? I just saw you.
They're on the list.
Unmute.
There we go.
Okay. Start video. Okay.
No, we don't need to start video.
Okay. You can hear me?
Yes, we can. Thank you.
You probably can't see me because I think you have muted or taken the video off, but that's okay. I'm going to speak to what, okay, I'm going to go, okay. Okay, I'm just going to speak as to what this neighborhood has become. Respect and common sense. I've lived, worked, played, and been a taxpayer in Canmore for over 40 years. We have lived in our current house for over 30 years, raising a family. What I loved about our neighborhood was the sense of community, knowing your neighbors by name, chatting to them in the middle of the street, my children and the neighborhood children riding their bikes, playing tag until they were called in. Dogs used to meet in front and roam around, following each other around. On a clear summer night, you could hear loud and faint noises, the trains, voices of neighbors several houses away. You could see the stars at night. We even used to block off the street and have potluck block party barbecues, laughing and talking while sitting by a fire barrel in the middle of the street. Now, our neighborhood has been bombarded by developers' construction noise for as long as I can remember, as the planning department approves more and more duplexes on Three Sisters Drive. Construction has been continuous for as long as I can remember, at least 15 years, 52 weeks of the year, 7 days a week, from 7 o'clock in the morning until 10 o'clock at night, with no end in sight. I don't know if you can understand how this alone has affected the neighborhood. When will I ever be able to sit outside and enjoy a Canmore magical evening again? My access to the downtown area has been limited by the removal of the handrail on the stairs by the power plant. The sidewalks have been chewed up by multiple construction sites on Three Sisters Drive. This is ongoing year after year. The stars have been blotted out by streetlights and 365-day-a-year blinking Christmas lights, making the neighborhood seem more like an inner city with flashing hotel lights. Walking has become an obstacle course around construction equipment, building materials, workers, and broken sidewalks. My home in an R1 neighborhood is my refuge, my piece of the Rockies, PEACE. I worked all my life to finally call it home, only to find that a hotel has opened up on the street. It is not what I would consider a B&B. Lou and Ellie Stabile operated a B&B on Three Sisters Drive for years without any complaints, because it was what I expected a B&B to be, a unique experience of home cooking, warm company, and conversations with hosts. What we appear to have on McDonald Place is a boutique hotel that costs $350 a night, that adds traffic, noise, and interruptions to the neighborhood by non-residents staying at the hotel, with no gain or benefit to anyone in the neighborhood. There are lots and lots of hotels, motels, and condo accommodations in the town. Lots of restaurants and ice cream parlors and gift shops. Lots of places for tourists to go. What do permanent residents get after paying taxes for over 40 years and finally retiring? A hotel operating in my R1 neighborhood. Continuous construction noise and no choice or control in the decisions made. We have given up our sense of community and lost R1 single-family dwelling neighborhoods, allowing development and tourism to take over every square inch of our neighborhoods. Where is the respect I think I deserve when I say that this is not a suitable use of this neighborhood and that all areas of town should have some democratic voice as to what goes on next door. Where else can I go? Thank you.
Thank you very much. Do any of the members of the board have a question for the Sullivans? Okay, thank you very much. And is there a fourth speaker now? Sorry, please
Hello.
unmute.
I'm opening my mute. Hello, can you hear me?
Yes, we can. Thank you.
The picture isn't coming through. I don't know that you would want to see me or not, but
And if you just
there you
please,
go. Start me there.
please
Now I can.
identify yourself.
I will. Thank you.
Okay, thank you.
There. My name is Louise Crawford. I am of the consortium of Louise and Glenn Crawford and family. And we have lived on the street for many years, not as much as our neighbors who have lived here 50 years from when the first development, when this was first developed, was in the late 60s, early 70s. And there are people still living on the street that are from that time. And they have been such contributors to the joy of living on the street. They've been like, you could just go to their door anytime and they would help you. Or if there was trouble, they'd be coming to your door and helping you. So we have a very strong community on the street, which is what I just, oh man, after my life of being in other places has been just joy every single day. Now, turns out I'm on the front of my house because that's where my kitchen is. So I get to be looking at my window all day because I love cooking and I'm doing all the things that go with it. So in this past year, I've seen the difference from once this, and really it is not a B&B came about. And we were hopeful. In fact, I put a little piece in here about, oh, you know, we'll just be positive about this, like Brian said, and there'll be the smell of blueberry muffins coming out as the guests are there. And just that kind of feeling of they'll be telling them about what a cool town Canmore is. And so it'll be that feeling of community. And then it just was like, oh no, that's not happening. And in fact, and nobody is coming in the front door. They're all going around the side. And then it just felt like an empty shell down the street that people could just come and go. And I would go out there and talk to them, but they were just getting in their cars and going. They weren't there. And so there was that feeling of, oh my, what has happened here? And then from that, it gradually came to be that, well, no, this is not a place that is now welcoming people. It is actually an Airbnb. And then when we looked online and that, we saw, yes, this is what it is. And one of the points I really wanted to make that came out here and is that in order to say that it's a B&B, you have to say there's that common entrance. Well, if the people, and I love you guys, Dale and Doreen, this is not against you. If the people are not there, there is no way those people could come in a main entrance or do anything like that. So if that's one of your requirements of what it is that you also this common entrance, well, that's just busted that right there. The point that Glenn and I and the other people that I've talked to on the street who they said they would put their names on with me, Donna Larson, Mary Lynn, that they were here with us for this, to be not against what has happened, but to say, you know, the town needs to have a clear definition. They have such a good definition for what all the tourist home business is. So somehow, because Dale and Doreen paid due diligence to what the rules and that were, they were able to work with the town to kind of move around and say it was a B&B, when in fact, maybe they didn't intend it to happen like that, but it has ended up being a tourist residence, a tourist hotel, an Airbnb, and that is against what should have been happening in our neighborhood. Last point is that what I feel has happened here is now it has opened a door, it has set a precedent so that when Shirley has to leave, which is not that far away, whoever gets to take her place will be able to go, well, you know, we're far enough away, we can do the same thing. And so it's opened up this door to the slippery slope of, well, if this is allowed, then this is allowed. And so this is why I came with this. It really is the town's responsibility to take responsibility for what has been allowed here. Thank you.
Thank you very much. Do any members of the board have questions for Ms. Crawford? Okay, thank you. I believe that then the appellants, that is all of the people speaking in favor of the appeal. Please unmute. Yes.
Thank you very much for accommodating us the way you did. I appreciate it.
Okay, thank you. So the next speaker will be the, oh, sorry, I need to ask the clerk if there's any additional correspondence in favor of the appeal, and if so, then to ask the clerk to read into the minutes any submissions received.
There were no submissions received that were aside from what was in the agenda package.
Okay, thank you.
You're welcome.
I would now ask the applicant to make their presentation with respect to the appeal.
Thank you, Mr. Chair. I appreciate the opportunity to address the SDAB of Canmore and my neighbors with respect to the issues relating to the renewal permit of our B&B operation. I am one of the owners and a full-time occupant of the home at 17 McDonald Place, and I am the operator, together with my husband, of Four Peaks Rocky Mountain B&B at that site. As between myself and my husband, I take primary responsibility for the operation of the B&B, but of course we share responsibilities and tasks in relation to that. I would like to thank the town for its consideration and granting of our renewal permit, and I'd like to thank the SDAB for the opportunity both to have submitted our written position, which you have already before you, and which I do not intend to repeat here, and also to address the board at this hearing. My intention is to make the statements that I had planned and then to take some time to comment and respond to some of the other submissions you've heard from the appellants and those speaking in support of the appeal. My husband and I designed and built our home on McDonald Place intentionally for the operation of a bed and breakfast at this location. And we have been operating that bed and breakfast for 14 months, having started operations in January 2021. Before completing the design of the home and proceeding with construction, we engaged in discussions with the town planning department. We reviewed the land use bylaw and other regulatory documentation we received from the planning department, documentation providing more detailed explanation of what they consider to be the requirements and restrictions for facilities and operation of a bed and breakfast. And we designed and built our home entirely compliant with those materials, all of them, not only the technical land use bylaw requirements, but also all of the supplemental materials that the town gave to us. During the 14 months that we've operated our bed and breakfast, there have been no noise complaints or disturbances at our home or related to our B&B that have ever been brought to our attention. I'm not aware of any having been brought to the bylaw officers. We've certainly never heard from any of our neighbors directly. We have provided all of the neighbors for whom we had contact information with our contact information ourselves, both phone numbers and emails, as well as a 24/7 contact line open to them, and encouraged them to communicate to us any actual concerns, disturbances, or interferences they might experience. We've communicated with them by email on multiple occasions, and have never heard of any complaints or concerns. I have heard Mr. Ald's description of having experienced some issues. That this is the first I've ever heard of that. So we've not had an opportunity to address that concern. But I can certainly say that we have not experienced issues with respect to noise in the suites or in the backyard amenity space. I do note that the town of Canmore gave notice of this appeal to the 2 homes directly behind and below our home. And those 2 homes would have their backyards directly behind and below our backyard and the amenity space for the units. The owners and occupants of those homes have not expressed any concerns. They have never indicated any concerns to me about any interference or disturbance with their enjoyment of their homes. And with the B&B space in the back of our home, they would be the ones most likely to experience any disturbance. There was a reference in one of the submissions to the facilities being non-smoking, and therefore people are, I think the word used was skulking about and smoking elsewhere in the neighborhood. Again, we've never heard that complaint before. We were notified once about some observed cigarettes, and we immediately attended to have those removed. In fact, we didn't find anything when we attended to go address that concern. But the guests are permitted to smoke in the backyard amenity space on the patio. So there is no reason for our guests to be smoking on the street or doing anything of that nature. We have freely communicated, as I said, with our neighbors, both in person on the street and by email communications, and over 14 months have never had someone express any complaints or concerns about specific incidents, actual disturbances or actual interference with their property, or actual objective concerns about their safety during those 14 months. I note that our neighbors 2 doors down at number 15 McDonald Place are not only not objecting to our B&B operation, but have submitted a positive statement in support of the B&B operation. The author of that supportive material, which is in your agenda package, is retired and lives full-time in the residence on McDonald Place. And her words about her observations, I think, carry a lot of weight and are of significance. She speaks to no disturbance, no interference, and no safety concerns on her part as someone who is here on a full-time basis and walks in the neighborhood frequently, including with children. She indicates that she has seen no objective basis for any safety or traffic safety concerns. It is, I think, important to note that the authors of this appeal have been opposed to our B&B from the first time they heard notice that we had an application for a B&B. That is significant because it was an objection that was raised before they had any information about how we would in fact day-to-day operate the business. They've been opposed from before we started operations. The appeal before you, even on reading it and listening to the submissions of the appellants and others, is not based on actual new objections by them, and it does not arise out of any actual negative experience relating to the operation of our B&B by us at 17 McDonald Place. There are vague suggestions about safety concerns, but no actual substance or evidence in support of an actual basis for a safety concern. There are other neighbors immediately beside us at number 18 McDonald Place has also got no objection to our B&B operation and has never expressed any concerns regarding safety of the residents of that home either. I also would note that some of the homes for whom owners have signed the petition objecting to our B&B are actually not occupied by those owners. That would include number 15 and across the street from us next door to the appellants. Those two homes have full-time long-term renters in them, and the renters, who are the actual occupants of the home, most likely to be affected by the operation of our B&B, are not here. They have not signed the petition submitted by the appellants, and they have not made any submissions in opposition to our B&B permit. In our discussions with them on the street, they've never expressed concerns to us, and in email communications to them, inviting them to advise us of any concerns so we can address them, they have never indicated that there are any concerns on their part. The appellants have raised a variety of arguments over the past 18 months since we first applied for our B&B permit, trying to find a basis or a way on which to shut us down. But this does not amount to actual interference in their enjoyment of their property or quiet enjoyment of their home. Our B&B facilities and operations are entirely consistent with and compliant with the provisions of the land use bylaw. The town has walked you through the neighbors' objections. They've walked you through in both their written report and their presentation this afternoon, their analysis of what those requirements and restrictions are, and how they have concluded that our home is entirely compliant with them. I note that the facilities as they are were reviewed by the SDAB last year when the same appellants appealed the issuance of our initial B&B permit, and this SDAB came to the conclusion that the facilities are in fact compliant in all respects, as the town has determined, with the land use bylaw requirements. So, Mr. Chair, when you specifically asked whether anyone is aware of any precedents relating to the interpretation of some of the terms of the land use bylaw, in addition to the town's consistent interpretation and application of those terms, this SDAB last year on appeal relating to our B&B operation came to the conclusion that our facilities are entirely compliant with the requirements of the land use bylaw. So there is a precedent, and it is a precedent that cannot be distinguished in terms of the facilities because it relates to the exact same facilities under question today. With respect to the question of cooking or food preparation facilities in the bedrooms or suites, which is one of the requirements of the land use bylaw that there not be such, the town does have guidelines and has long had guidelines that dictate and determine how that has been consistently interpreted by the town. The planning officer has walked you through that and explained what those interpretations are. And I submit that this particular renewal permit appeal hearing is not the proper time and place for this board to choose to now change that interpretation or impose upon us as a single B&B operator a different interpretation of the land use bylaw provisions. To do so would be unfair and unjust to us and would create an unlevel playing field throughout the town of Canmore, where the past interpretation, which has been established for a long time, has been applied to every other B&B permit applicant, including on renewals, for some time. I do note that the town of Canmore specifically and personally inspected our B&B units, both at the time of our initial application for permit and again very recently in respect of this appeal. And so they have seen exactly what is available on site. They have confirmed that it is consistent with the land use bylaw and compliant, and that it is consistent with their understanding of what other B&Bs provide or have for facilities. As well, the Canmore Bed and Breakfast Association inspected our site in 2021 after we received our permit and became a member of that association. That association, of course, has a real interest in ensuring that the bed and breakfasts that are members of it and that are operating within the town of Canmore are doing so legally and pursuant to valid permits and in compliance with the land use bylaw in all respects. The Canmore Bed and Breakfast Association has confirmed that they understand we are doing so and are not operating in a manner significantly different from the standards of the other members of that association. There is, in fact, in our facility, no stove or oven or microwave. There is only a bar fridge. There are no overhead cupboards, all as required and restricted by the town according to its interpretation, its longstanding interpretation of the land use bylaw. There is no means within the interior facilities of our bed and breakfast units for our guests to prepare a meal or cook a meal. In other communications to the town and now in this appeal, the appellants have invited town staff and the SDAB to read in requirements or restrictions for B&Bs that are not present in the land use bylaw. This permit application, the renewal permit application, is not the proper time or the proper forum or process for our neighbors to try to effect a change in long-established town policy about the allowance for bed and breakfasts in R1 residential areas such as the one we live in. To undertake a change to the actual policies, and I submitting that includes the way those policies would be applied by either the town or the SDAB, should require a proper process to amend the land use bylaw to give clarity to all B&B operators as to what the rules and requirements and restrictions are. This is not that process. That process would require notice to the public of an intention to actually change the bylaw and the rules and regulations affecting B&Bs in the town of Canmore. A change to the bylaw would require a full public process involving all of town council, as it is a bylaw that can only be passed or amended by town council, not effectively amended as to its application by this subdivision development appeal board in our submissions. Any such change would have an effect on all of the other B&B operations in town, which I understand from the town's submissions and materials includes as many as potentially 50 businesses operating peacefully and without issue in this town. For this development appeal board to refuse or impose unreasonable restrictions or conditions on our operation would be to treat us unfairly and differently from the way that every other one of those B&B operations is treated by the town of Canmore. Relevant planning policy documents are before you in the materials that have been presented by the town and by us, and some of them are referred to by the appellants in their materials as well. I note that the Municipal Government Act, section 687, subsection 3, sub D, deals with the ability to permit a development that doesn't even comply with the relevant land use bylaw. And that can be done if there's no undue interference with the amenities of the neighborhood and if it does not materially interfere with or affect the use, enjoyment, or value of the neighboring parcels. I'd submit that if a non-compliant application could be approved under the MGA, as long as those conditions were satisfied, then certainly our renewal permit must be granted when it is in fact compliant with the land use bylaw as determined by longstanding town policy and the town, and as we suggest, the clear meaning and intention of the land use bylaw provisions. It cannot be that we can be refused a permit for a compliant operation or use when a non-compliant one could be approved. The land use bylaw also states, as has been alluded to, that the use should not shall not interfere with the rights of other residents to quiet enjoyment of a residential neighborhood. And our submission is that there is no objective evidence of actual interference with the quiet enjoyment of the residential neighborhood. And the submissions by our neighbor at number 15 McDonald Place confirm that there is in fact no such objective interference. I suggest to you as a subdivision development appeal board that when considering the alleged effect on our neighbors, you must consider how real any alleged impacts are, and you must consider the quality, if any, of the evidence of actual impact as opposed to subjective discomfort or unfounded fears or anticipation of problems. And you must consider the materiality of the alleged impacts as well. None of the issues raised as fears in the appeal before you are substantiated by any evidence. General references to concerns about having strangers in the neighborhood does not amount to evidence of actual interference with their quiet enjoyment of their properties. The appellants have referred both in their written submissions and in their comments today briefly to the Town of Banff Committee report as to what should happen with respect to a B&B. The fact that they're referring to that, I think, is interesting. It relates to a committee that the Town of Banff struck to undertake consultation and thought on the question of what should be the rules and regulations relating to B&Bs. That was done after extensive discussions and consultations. It was, of course, done in another municipality that has some of its own unique issues and considerations. The appellants refer to the report in their written material, suggesting that it came to a conclusion that certain activities are daily duties of a resident, implying that the Town of Banff Committee recommended that it should be required that the homeowner operator personally perform all of those listed tasks. That is not what the Banff report says. It actually says that it recommends that the owner would normally be involved in a variety of aspects, such as those listed. It does not say that the owner should be involved in all of them. In fact, we are personally involved to some degree in all of the aspects of services associated with the running of Four Peaks Rocky Mountain B&B at 17 McDonald Place. With respect to cleaning, I don't personally do the cleaning. I think the appellants have acknowledged that it's not unreasonable to hire professional cleaners and maintain commercial standards. I'm happy to hear they acknowledge that. The same is true with respect to laundry. In terms of managing a website and online service, we maintain our own website for Four Peaks Rocky Mountain B&B, and the link was provided. The link to that B&B, that website was provided in our submissions. That is our creation. It is maintained by us, and responses or inquiries we get from it are responded to by us. Our B&B is also listed on the Canmore Bed and Breakfast Association website, through which we also market our property and our business. We get inquiries through that website and we respond to those personally ourselves. We also do other bookings directly. In addition to that, our facility is listed on Airbnb. What that is, that does not make us an Airbnb facility. There is no such thing. Airbnb in this context is simply a reservation system that is conveniently used by a wide variety of different types of accommodation, which is convenient to market your facility and services and provide a means of easy communication with guests. We use that service, and we have a contractor who assists us in managing the use of the Airbnb service because they have experience and expertise in doing so. Another one of the tasks listed in the Banff report relating to operations by the owner operator is communicating online or by phone with potential guests for booking inquiries. We do that both online, by email, and through the two websites that I've referred you to. In terms of cooking or preparing breakfast, we don't serve a hot breakfast, but we do personally attend to all of the work associated with providing breakfast food to our guests for consumption in their suite on their own schedules. I have established personally accounts with local businesses to provide locally sourced and supplied food for that purpose, such as Eclipse Coffee Roasters and Le Chocolatier. I do all of the food purchasing that is provided to the guests. Before each guest arrives, I set up the food in the suite and make sure that it is what they have asked for. The survey that goes to guests as part of their confirmation of their booking, those survey results come directly to me. I review the survey results. I follow up with guests who don't complete the survey to contact them and request that they do so, or otherwise advise us of their breakfast needs. I follow up with them after the suite is set up and after they're in to ensure that they have received the food that they want and need. And on stays that are longer than a few days, I follow up with them during their stay to see whether they need any of the food refreshed, and I purchase it and I personally provide it to them. One of the things that is indicated in the Banff report is arranging for someone else to attend to the site when the owner operator is not at the property for a period of time. That is something that we also do. It is not the contractor S&T who manages or handles the Airbnb site for us. We hire a local responsible adults who attend to the site on a daily basis. If we are not able to be here that day, they fulfill all of the roles and responsibilities that we do at the site during regular operations. We do not necessarily meet and check in guests at the time of their arrival. It's true that few of our guests come to the front door to be greeted on their initial arrival. That is not required under the land use bylaw, as the planning officer has explained. It is not a common practice at lots of B&Bs. Many B&Bs operating in Canmore and around the world now offer guests flexibility as to their check-in time by having the type of access to the B&B facilities that we offer to our guests. This is not unique. It is not inconsistent with a proper B&B operation. In fact, it is becoming a norm wherever that is physically possible at B&B sites. We do, however, engage with our guests, and the appellant's submissions that we don't engage with our guests is simply inaccurate. They may be basing that on the fact that during their observation of our operations, they haven't seen guests at our door. But I suspect they have seen us engaging with our guests on the driveway, either around the time of their arrival or at other times during their stay, because it certainly happens on a regular basis. As well, as you all know, it's required that there be access through the home to the B&B suites. We use that access to go and meet our guests and engage with our guests and to answer their inquiries. One of the people who spoke in support of the appeal expressed the disappointment to think that we aren't talking to our guests about the town of Canmore and all it has to offer. We do that. Our website gives them information about things to do in the town and things to see in and around this area. It gives them lots of links to information, and we supplement that by making the effort to meet our guests and speak with them on site, because we are in fact the resident on-site owner operators of this business. And we do that on a very regular basis. With respect to building and property maintenance, that is something that we attend to. We do the snow clearing on the site. We maintain safe sidewalks and entry access to the guests. We attend to repairs of anything in the sites that are in the suites as required. Although given how new they are, there haven't been much in the way of maintenance needs, but when they do arise, we attend to them. And of course, with respect to accounting, we maintain the accounting, we report the income associated with this business for tax purposes, and we track the revenue and the expenses closely, just as we track all of the bookings and keep track of our reviews that we receive from guests through any means and respond to those reviews as well. So to the extent that the appellants or our neighbors don't perceive us to be actively operating this B&B, I suggest that their perceptions are limited because they haven't come to talk to us about it, and because they can only see what they can see through their front windows, and that it is inaccurate for them to suggest that we are not actively engaged as operators of this business. Our letter to the town submitted with our renewal application provided additional information regarding tasks that we do in relation to the B&B operation, and I will refer you to that as well without taking the time to repeat that information here. Suffice it to say that there is extensive interaction between the guests and ourselves through a variety of methods, including the survey, text messages before and during their stay, telephone, email, and in person. When they do contact S&T with respect to any questions or concerns or needs, because they have that contact information through Airbnb, and because we've taken advantage of the opportunity to have a 24/7 customer service line, those inquiries or requests are relayed to us and we attend to responding to them. It is also inaccurate for the appellants to say that when we are on vacation, no one enters the home. That is absolutely not true. We, as I said, have local responsible adults who we engage when we have to be away from the home or when we take a vacation to fulfill all of the roles and responsibilities that we fulfill on a daily basis. They come and enter the home through the garage, not through the front door, because our front door does not have easy access for them, but the garage does. They enter the home through the garage directly into our living space. They check our home. They make sure our home is safe and secure. They check the suites, and they provide all of the needs of the guests, including the regular breakfast food setup that we would do, as well as maintaining the property in our absence. I've already spoken briefly about our contract with S&T. This does not amount to S&T being an absentee Calgary operator of our B&B. We are the resident present operators, subject only to when we have to be away for family commitments or choose to take a vacation, which I know the land use bylaw does not prohibit in any way. And even the town of Canmore report contemplates being permitted. S&T has experience at using the Airbnb booking platform, which is what it is, to manage reservations and communications with guests. As new operators, we thought it advisable and prudent to ensure that our guests have an excellent experience, that we're running a top grade B&B operation, and we entered into what is a marketing contract with S&T to engage them to use their skill to assist us in marketing our B&B on that platform, while we market on the two other platforms that I've mentioned to you, as well as by word of mouth. By using S&T in that way, we secured access to a means for our guests to always be able to contact someone 24/7 through their customer service line. This shouldn't be prohibited. It shouldn't be criticized or complained about. It should be applauded as ensuring top quality service and ensuring that our guests will always be cared for. S&T is not on site. Tina is not on site. We are the on-site resident owner operators. Our communication to guests, which is issued automatically through Airbnb when a booking is confirmed, clearly indicates to guests that we are the on-site owner resident operators of the B&B, and explains to them that we are available, we are happy to greet them, and that we are also available to assist in any way they need. As I noted, S&T has no involvement in the provision of food for our guests, and because they're not on site, they play no role in inspecting and monitoring and supervising the work of the commercial cleaners and laundry service. That is done by me. After every guest leaves, I check the suite to make sure there's been no damage, to make sure that things are in order, and to clean out any leftover food from the breakfast food that we provided. The cleaners then come. The cleaners come only on a changeover day. They do not attend the sites on a daily basis. And I make sure the cleaners do show up. I follow up if they're not here within the contracted time frame. And after the cleaners have come, I go and inspect their work. I make sure it's done to my satisfaction or make any corrections or adjustments to it. I inspect to make sure there's still no damage to the suite. And I personally set up the breakfast food for the incoming guests on the day of their arrival. The appellants have talked about the shared experience as they view a traditional B&B. The fact is that generally bed and breakfast businesses have evolved over the years, and they have evolved away for many operations. They've evolved away from the type of shared experience that our friends are talking about. This does not make them not B&Bs. It simply means that there's been an evolution in the bed and breakfast experience. There's room in the marketplace for different types of bed and breakfast experience. Some operators still choose to have the very shared experience. Some of them, that's all their facilities allows them to have. Some of the traveling public want that experience and will book it. Others prefer the more private and independent B&B experience that we offer them. But it is no less a B&B experience and no less a legitimate B&B experience just because they don't have breakfast at our table. There's no legitimate policy reason for the town or the Subdivision Development Appeal Board to exercise whatever discretion it has in the ways that the appellants are advocating for here. It would be irresponsible in my submission for the town to require that the individual owner operators do all of the cleaning and laundry personally, rather than to allow and approve the hiring of professionals to ensure commercial standards of cleanliness are maintained. And during the time we've been in operation, COVID has been a very significant concern and consideration for everybody, including us and the traveling public, including our guests. So the highest level of cleanliness and sanitation is of utmost importance, and we've taken reasonable steps to secure that and ensure it, and should not be criticized or penalized for having done so. Similarly, it would be irresponsible, in my view, for the town or this board to require guests to enter the rooms or units through our home where the facility doesn't make that necessary, particularly at the time we are in now, with physical distancing being important and necessary, and in some cases mandated by public health orders. It would be illogical in the Bow Valley to prohibit owner-operators from ever hiring others to assist them in providing their B&B services, creating employment, and supporting other local businesses and other individuals in the town who wish to be able to live in this town but need the additional income. Note that when the land use bylaw says that access shall not be solely through a separate private entrance, it clearly contemplates and allows for the existence of that separate private entrance, and it must be interpreted as allowing the choice of the guests to use it if that is their preference, which has been the case for our guests. I disagree with the appellants who suggest there's any lack of clarity in the land use bylaw, and I particularly disagree with their suggestion that if there is ambiguity or lack of clarity, the land use bylaw should be interpreted in their favor as other residents on our street. In fact, I would suggest that if there is ambiguity, the affected party is me as the property owner seeking a permit to carry on a business that is possible under the land use bylaw, and any ambiguity should be interpreted in favor of us, and certainly should be interpreted consistently with the way it has been interpreted for years by the town of Canmore. While the town of Canmore may have decided not to have short-term rental homes in R1 districts, and I fully support that. That is not what we are doing. We have never rented out our home. The town of Canmore previous councils clearly decided to permit there to be B&Bs in this type of a residential area. And such B&Bs have operated successfully and peacefully throughout the town of Canmore in neighborhoods just like this one for many, many years. There is nothing in relation to our B&B operation or facilities that would support denying our renewal permit at this time or imposing any additional conditions upon our operation. There's nothing sufficiently unique about McDonald Place or our property that merits any differential application of the land use bylaw provisions relating to B&Bs to us as compared to any of the other 50-some B&Bs apparently permitted and operating in Canmore. The intended use of having the operation of a small in-home B&B is entirely consistent with the intent of this land use bylaw. And within our area, there are other B&Bs permitted and operating successfully and without difficulty. The number and location of them is controlled under the land use bylaw, and there was room, according to those controls, for our home to be granted a permit to operate as a B&B. In relation to the traffic considerations that the appellants have raised, I submit that the land use bylaw manages that issue already by limiting the number of B&Bs in an area and therefore the related traffic, and limiting the number of rooms or guests and that can be in each B&B, therefore limiting the traffic that would come to each specific home operating as a B&B, and by requiring on-site parking, which, as the town staff have indicated, we have exceeded that requirement with our property. The appellants have referred to accessibility to amenities and necessities and suggested that walking is not possible. Firstly, that's not a requirement under the land use bylaw, and to read in any such requirement or restriction would be improper. I note that we personally typically do walk or bike ourselves, including to get groceries much of the time, and that for many people, Main Street is an easily walkable distance from our home. In fact, reviews for our B&B operations have confirmed that many of our guests have enjoyed the proximity to town and the ability to walk to amenities. We have not been advised of any complaints regarding driving behavior from our guests. None have been documented. Today is the first time I've heard that there has been any incident where any of our neighbors have approached any of our guests to try to talk to them about their driving behavior. It's unfortunate that we have not been advised that this was an actual concern, but I note that the residents and owners of number 15 McDonald Place have never observed any such concern. All of our guests have parked on our property in the designated stalls, and the one time somebody didn't, we addressed that issue promptly. Typically, as with most visitors to the Bow Valley region, our guests attend at the site and then they're either home for the day or they're out for the day exploring the beautiful area that we all get to call home. There is not typically a lot of traffic coming and going from the home multiple times a day or night. And I note that my friends have not documented any such experience. The amount of traffic, as the town of Canmore planning staff have identified, the amount of traffic associated with our home, including the B&B operation, is no more than one would experience if there were multiple licensed drivers, more than 2 licensed drivers living in this home. A family with young drivers, each having access to vehicles and driving to and from the residence, would have as much traffic as our B&B generates. If we had billeted a hockey player or had billeted a foreign student or a guest student in our home, there would be no less traffic. The amount of traffic associated with our home is no greater, even with the presence of the B&B operation, than we see at some other homes in the neighborhood. The suggestion that our guests don't know how to drive in a residential area is inexplicable to me. Our guests are typically mature adults or young families familiar with driving in residential areas, such as McDonald Place and Three Sisters Drive. There's no reasonable basis on which to find or suggest that our neighborhood streets and our neighborhood are now any less safe with the presence of our B&B operation. The appellants repeatedly refer to our B&B as unsupervised, which is an unfair and inaccurate statement. The vast majority of the time, we are present on site most of the day and most of the night when the B&B is operation. When we take vacations, as I said, we have responsible adults who attend to the home on a daily basis. If I can just take a moment and take a look at my notes from the appellant submissions, I may have a few additional comments for them or in response to them, Mr. Chair.
That'd be fine. Just take a couple of minutes.
The appellants in their submission made a brief reference to the fact that having a B&B operation in our home somehow displaces local housing. I don't think that has any legitimate consideration in the context of our application for a subdivision development permit renewal, but certainly I don't think it is the role or place of this subdivision development appeal board to deny our application for a B&B and hope that somehow that might result in some other type of accommodation being created instead. Our application is for a B&B and it should be considered on the basis of planning principles and whether our B&B is compliant with the land use bylaw and whether or not our B&B operation actually and materially interferes with the enjoyment of the neighborhood for our neighbors. The appellants raised the question of how is it monitored that the number of guests registered is actually the number of guests staying at the B&B. Well, that is monitored by us as the owner operator who is present on site when the B&B is in operation, or by the individuals we engage to attend to the site when we are not able to do so. We have had only one occasion that I can remember where it appeared that more people than were registered attended at the site, and we immediately spoke to them and followed up with them and determined that only the registered number of people were staying in the suite. The others left and went somewhere else. So this is something we're conscious of. We're very alive to the need to meet and adhere to the requirements of our permit, and we take active steps on site to make sure that that happens. The appellants made a reference to the notion that if you allow us as full-time permanent residents of this home to operate a B&B using contracted services on occasion and for certain roles, then the slippery slope will be engaged and you'll suddenly have B&Bs being run by weekend-only residents of Canmore. I submit those people may not be able to truthfully swear the statutory declaration that I have sworn and which I take seriously. And I also submit that you can't reject our permit application on the basis of a fear that somebody else might engage in a business that would not be compliant and not be proper or consistent with the land use bylaw requirements. I do not agree with the appellants in their suggestion that somehow the town planning department stretched their interpretation of the land use bylaw to allow our somehow overly creative B&B operation. Rather, we ensured we knew what the town bylaw said and how the town interpreted that bylaw before we ever decided to engage in this business, before we designed and built the facilities that we operate as a B&B. No stretching was required because we are 100% compliant with every requirement and every restriction that the town of Canmore had and has ever had before we started operation or has had at any time during our operations. I submit that our operation is not the same as a short-term vacation rental of our home. And to suggest that it's unfair because other neighbors can't do a short-term rental of their home or use Airbnb as a platform to do that misses the point. We are not simply renting out our home. We are operating a B&B, providing services to guests in a designated portion of our home, fully compliant with the land use bylaw. I just want to make clear that to the extent that one of the people speaking in support of the appeal made a reference to blinking Christmas lights all year round, I know what she's referring to, and that is not our home. Members of the board may not have appreciated that, and I think it's a minor point, but one worth mentioning. Our home does not have any hotel lights, as we're referred to, or any blinking lights. We have a subtle sign that you can see on the picture of our home on the front of our garage, which has a small subtle light so that it can be read during the darkness hours. I don't believe it's fair for the appellants or those supporting the appeal to suggest that what we're operating is a hotel. What we are operating is a B&B as defined by and allowed under the land use bylaw. It is distinct from a short-term rental accommodation unit, and it is distinct from a hotel. And in all respects, we are compliant with the land use bylaw in this respect. I want to note that Airbnb is used as a reservation system, not just by us. This is not something unique to us. Airbnb is a booking platform that is used by all manner of different types of accommodation. This includes other what I think the appellants would call traditional B&B operations in Canmore. Many are listed on Airbnb because technology has simply overtaken the old way of doing things. Technology is now the way that business operators communicate with and engage with the public, both for marketing purposes and for arranging bookings, maintaining booking calendars, and confirming bookings. That does not make us anything other than a B&B operation. It is simply an evolution of the reservation and booking process that has happened with the development of technology. I think I've spoken to the various comments that I wanted to, and so with that, I'll close my presentation and would be happy to answer any questions any members of the board have for me.
Thank you for your presentation. Do any members of the board have questions for the applicant? Mr. Giraldo.
Question about access. If you are not present at the home, can guests gain access to their suite through the front door of your house?
Not if I'm not present in the home, no.
So if you are not present and you say you're away on vacation and an individual is coming in to check on the suites and the safety of your own home, the guests do not have the option to access their suites through your front entrance.
The guests could make the request to be greeted, and then we would have that individual arrange to meet them and greet them and show them to the suite. That has not occurred though.
Okay, thank you.
Any other questions? Ms. Coos.
Thank you, Mr. Chair, and Ms. Sanderson for your presentation. I do have a couple of questions. The first being, we've heard a couple references to planning guidelines or planning policies that supplement the LUB and assist the town planning department in interpretation of the legislation and the LUB. I have asked the representative from the town if there is a guideline and if there's a copy. I was told no. So I'm just wondering if you have a copy of a guideline or a policy that helps with, from the town of Canmore, that helps with interpretation of the LUB and supplements that documentation.
I do have, I believe it's a 1-page, possibly 2-page document that we obtained from the town planning department when we were first planning our home and contemplating operation of a B&B. I had thought that it had been submitted with our materials, but I see that we inadvertently attached the checklist of the planning documents and not that document. I can have a scanned copy of that hard document made and sent to the clerk after this hearing, if that would be of assistance to the board. I'm sorry that it did not make it into the package, but that was the additional material that we relied on in planning our operation. It contains some of the things such as the development officer spoke to in his submissions, like the fact that you could not have overhead cupboards, you could not have a full-sized fridge, you had to have certain safety equipment, you had to have the access through the home, some of which was in the land use bylaw and some of which was supplemental to the land use bylaw, putting some, I guess, concrete measures to their interpretation of the requirements. So I certainly can send that to the board clerk after this meeting.
That would be appreciated. Thank you. Secondly, and further to Mr. Giraldo's question relating to access, I am wondering what percentage of your guests actually access their units through the primary dwelling as opposed to through the exterior outside doors.
It's true that the very few of them access their suites through the primary dwelling. They, especially in the time of COVID, but I think generally they prefer to use the private access to have the independence and the freedom to come and go at any time and not to have to check in at a set time when we would be necessarily home to greet them. We do use the access through the dwelling to interact with our guests, to go and introduce ourselves, to ensure that they have everything that they need for a pleasant stay, to share information about Canmore with them, and to engage in greeting and discussions with them while they're here.
Okay. When you say very few, over a period of 14 months, approximately how many in the number numerically have you had prefer the interior access?
I'm not sure there's been anyone who preferred the interior access.
Okay. So perhaps nobody?
Some have accessed the home from the suite, but they have, I think, all originally entered the suite through the exterior access.
Okay. And when you greet guests through the interior access, I just want to understand what those access points look like. Are there locks on both sides of the doors, or are there locks simply on the guest side of the door? Are they free to enter your primary portion of the dwelling at any point in time to get out through that door? Can you help us understand that a little bit better, please?
There are locks on the doors. They're capable of being locked. They are not always kept locked. We've had some guests ask that they be kept locked and that they maintain their privacy.
And that's on the guest side or on your side?
They can be locked or unlocked on both sides.
And my next question relates to the kitchen. As you're aware, it's an important element of section 8.3 of the LUB. So I just want to understand that a little bit better. Cooking and food preparation facilities. I guess if I look at the layout that was provided in the materials, the layout of the two units appears to include a kitchen space and an eating space. And it's contrary to what I've seen in your materials and what we've heard from you today. And that's that there is a small wet bar and a mini fridge. In some places it says there's a dishwasher. Some places it says there isn't a dishwasher, that there is a sink. Just want to get a better sense of what is and what isn't there. So, and I don't see any pictures of what's there. So perhaps if we just walk through a quick list of what I think entails a kitchen, you could help me understand. But I understand you have no top cupboards.
Correct.
Do you have shelves?
No, we have bottom cupboards, a short row of bottom cupboards and drawers, but no shelves or cupboards above.
Okay. And then the fridge is a mini fridge, I understand.
It's an under-counter size bar fridge.
A stove, is there a gas stove or electric stove or stovetop burner?
There is no stove or burner of any kind in the suite.
Okay, microwave, I understand there's no microwave.
There are no microwaves in the suites.
Toaster?
There is a toaster in each unit,
Yeah,
which we understood from the town's documentation and material obtained before we started was permitted.
Okay. And of course, I don't know this. I appreciate you walking me through this. So me and the board have a better understanding of this going forward. A toaster oven?
There is no toaster oven.
Okay. Dishwasher, is there one? And the materials were a bit confusing at that point.
There is a dishwasher in each unit.
Okay. A sink?
There is a small single sink in each unit, aside from the bathroom.
Okay. Plates and bowls?
There are dishes.
Okay, and then would that be 4 for the 2-bedroom unit and 2 for the 1-bedroom unit?
I think we provide more than that so that they don't have to wash them after each use and they don't have to run the dishwasher after each use.
Glasses, mugs?
There are glasses and coffee mugs, yes.
And cutlery?
Yes. A limited supply of cutlery.
Okay, knives for cutting or chopping?
There might be one knife in each suite that could be used for cutting. That's not something we made a standard.
Okay, cutting boards?
There is a cutting board in at least one of the units.
Large bowls?
There are some bowls, yes.
How about pots or pans?
I'm not certain. There may be a pot or pan in one of the units. It's not something we consciously stocked the units with.
Okay. Serving platters?
No, not to my knowledge.
Okay. Serving spoons?
There's probably one larger size spoon than a tablespoon, yes, in each suite.
Okay. And then from the layout, it looks as though the kitchen area or the kitchenette I've heard used has seating area. Are there tables or counters for seating and eating purposes?
Each unit has a small kitchen table and an appropriate number of chairs, 2 in one suite, 4 in the other.
And then
that's where they eat the breakfast, right?
Right. And then I see reference in the land use bylaw relating to plumbing equipment and cabinets for dwelling units. If you're at that end of the spectrum, what sort of plumbing is in this area other than just plumbing for the small sink and I guess the dishwasher?
That would be it.
Any other kitchen type of equipment?
No.
No food processor, mixers, that sort of thing.
Okay. There might be a blender in one of the units.
Okay, and then the primary use of the kitchenette area that we've just described would be for, could you just confirm for me what the primary use for that is for your guests?
The primary use for the kitchen area would be for them to put together their continental breakfast with the food that we supply to them, such as toasting bagels or bread. It would be used for, making a bowl of cereal if we provide them with cereal, boiling water and making some instant oatmeal if that's what they've requested and we've provided to them, and eating their breakfast there. Sometimes when I travel, because it's an active place like this, I might have some food to make myself a packed lunch to take with me. I don't know if my guests do that or not.
Okay, and then thank you. I saw reference also to a checklist for ingredients that you provide to your guests. I don't see the actual list. I was just wondering what types of food that you do stock in the units for breakfast. You made mention of bagels, potentially, or oatmeal. What other types of foods are stocked for breakfast?
So the survey asks them to indicate their bread preference, which could be brown bread, white bread, bagels, or muffins. It asks them their preference with respect to cereal, which could be individual size Kellogg cereal boxes, like the variety pack, or it could be granola, or it could be instant oatmeal packets. It asks their preference of fresh fruit as between apples, oranges, and bananas, or a mixture of those. It asks their preference as to what type of milk. It can be either 1%, 2%, or almond milk. It asks if they want orange juice. And it asks if they want yogurt. We provide the small individual serving size yogurts as well if they're requested. All of which is then stocked in the suite, refreshed during their stay if necessary, and consumed in the suite in their privacy. We also provide a variety of teas, and we provide coffee.
Okay, thank you. And then I just have a better understanding of what the kitchenette is now and what the use of the units also is. One last thing, I heard reference to barbecues. Are there barbecues for the units and their use, or is that only at the primary dwelling in your use?
No, there are barbecues outside that the units are allowed to use.
So would there be utensils and equipment for the use of the barbecue as well?
There are barbecue tools provided, yes. All of which our understanding from the town was permitted based on our discussions and research before we began operation.
Okay, and is that set out in the guidelines and the bylaws, the policy that you're going to provide after the meeting?
I don't honestly remember if barbecues are referenced in that document or not. I'll have to pull it out and take a look.
That'll be helpful. Thank you. No further questions for me. Thank you.
Thank you.
Mr. Chair.
Thank you. Are there any other questions for the applicant? Ms. Mara.
Thank you. I'll ask my question through the chair to the applicant. Most of my questions were asked by Ms. Hughes. Mine is in relation to the parking. You mentioned that you have talked to your clientele, your guests when they bring or park in the wrong spot. Do you have many people coming with two vehicles to your two-bedroom unit, or is they usually coming in one?
They are usually coming in one vehicle, but there have been occasions where there have been two vehicles associated with the two-bedroom unit. I couldn't give you an estimate of the number of times or percentage, but I would say it's less than half the time that there would be two vehicles associated with that unit, and anything else I don't want to misstate or risk giving an inaccurate estimate.
No, and where would you suggest they park their second vehicle?
They often park in tandem in one spot, one behind the other. And if necessary, they could park blocking one side of our garage, but they typically don't.
Thank you.
I could just add, because you raised it, if I might, Mr. Chair, the reference to people who parked improperly. There's only one time that I can remember we had a guest who parked on the street instead of in our designated parking spaces, and we asked them to move, to which their answer was that they were actually friends of the neighbor and had permission to park where they were parking or understood it would be acceptable. We still asked them to move to the designated parking spot, and they did so. I'm not aware of any other occasions of an issue about that.
Thank you. I have one question, please. It relates to a section of the bylaw that I raised with the development officer earlier in the hearing. And that's section 8.3.0.14. I would appreciate your views on what evidence needs to be provided and burden of proof. You have commented earlier on evidence and burden of proof with respect to quiet enjoyment. This is a slightly different section.
I'm not, if you could remind me what the section you're referring to is, please, Mr. Chair.
Yes, I'll read it out again. No issue with that. At the discretion of the development authority, bed and breakfast developments may be permitted on the same site as a home occupation where an applicant has adequately demonstrated that such an approval would result in negligible increase in noise, traffic, or parking on the property or in the neighborhood.
Well, to the extent that that section specifically relates to a bed and breakfast where there's also a home occupation, I would echo the comments that the development officer made about that the nature of the home occupation that is carried on at this home is my husband's consulting business. He typically deals with clientele in Calgary or elsewhere. His business is such that there are no clients attending at our home for purposes of that. He does his business electronically or attends meetings in Calgary if he has to, but the whole time we've been in operation, that frankly hasn't been happening due to COVID. So in terms of the burden of proof, I would suggest that the information we can give, which is concrete, is that at any given time at our home, there are our vehicles and there are 0 to 2 guest vehicles, very occasionally 3 guest vehicles, all of which park on our driveway. You know, being in the home, we aren't disturbed by the guests coming and going. Them being on our driveway, we're not disturbed by them coming and going. And so it is puzzling to me the extent to which our neighbors seem to be bothered by having those typically passenger vehicles parked on our driveway or driving onto the street and into our driveway.
Okay, thank you for your response. Are there any other questions before we move on to the next item of the agenda? Seeing none, then.
I was just, Mr. Chair, sorry to interrupt. Is there any opportunity to provide any of the inaccuracies that I just heard?
I would, I permit one question very brief, or one comment very brief, please.
You guys can hear me here. I would have to say that the question I would have just that being that where I am on the neighborhood street, I'm at the end of the cul-de-sac, and almost everyone, and it's not their fault or anything to that effect. They would generally drive around the street first before they find the location of the bed and breakfast, and it's totally understandable that that's what would happen, but that definitely increases the traffic. And I have a bird's eye view of the entire street. If there's anybody that can make an accurate statement of what's coming and going, I get a view of everything. And so to simply say that strangers' cars are the same as having like having a billeted person, a new stranger every time. I just find it really insulting that we would be interpreting bylaws in such a way that would be, yeah, you're following the laws, great, but you're not making a community. You're not actually participating with the community. It just seems it's just nonsense. I can't believe what I just heard. But anyways,
Okay, well,
I'm sorry, I had to say.
I think that we've heard your point, and we'll move on to the next item, which is, are there any others speaking in opposition to the appeal?
Yes, Mr. Chair, we have in the registered, we have Carol Poland, and she is present right now in the meeting.
Thank you. Is she, are you online? Oh, I see. Thank you. Yeah, please unmute yourself, Ms. Poland.
Thank you, Board. Can you hear me?
Yes, we can now. Yes.
Thank you, Board. Respective of time, I've been on with you all since 2 o'clock, and I respect now it's 5. But I would like the opportunity, may I have 3 to 5, maybe 3 minutes?
Yeah, 3 minutes would be fantastic. Thank you.
I will keep my comments to that. To the Board, my name is Carol Poland. I'm here today to speak as opposed to this appeal and ask you to oppose it. I am speaking in 2 hats. My first hat that I wear is I am an owner-operator of a Canmore licensed bed and breakfast in this town, of which it has been licensed since 2015. And we are second owners. It was purposely built in 1997 and has always been compliant. I'm also speaking with my other hat, which is I'm the past president of the Canmore Bow Valley Bed and Breakfast Association, of which this appeal is discussing a member of the association of which I belong, and they also have been inspected and belong to. Our association is a not-for-profit, self-governing association. Admission into our association requires, number 1 in our bylaw, that you must be adherent to the town of Canmore bylaws and rules and regulations. And I must say that we were very proud to have this 17 McDonald Place, 4 Peaks Rocky Mountain, apply to our association. We inspected it under our rules, which are more extensive than the town's, and they have been compliant. They have been compliant with our association rules and compliant with the town. So my only comments are 2 that I'd like to make, and I'm happy to answer any questions that the Board might have of me. One is the bylaws that the town have. I've read and read again. We must adhere to them, as well as currently the the business that's under question today. There are 13 very detailed bylaws by the town of Canmore, and I see none that have been broken here. And I ask this Board to stay with your mandate of upholding the bylaws, which this business is upholding. In the last 3 hours, I have heard quite a discourse of discussion of what is an Airbnb versus what is a bed and breakfast, what is a traditional versus what is evolved into. I'd be happy to take that offline with you, but I would propose, as has the complainant, the V&B who's under question today has also alluded and recognized that's not for today's discussion. If we want to change the bylaws, if you want to amend the bylaws, our association would welcome the opportunity to be a resource and enter into discussion with the town and with the Board on how to change the bylaws. But when I review the bylaws that you're currently working under, maybe they're not perfect. I see wiggle room everywhere too. But I know that all members of our association, including this 4 Peaks Rocky Mountain Bed and Breakfast, which is under discussion today, have been very, very compliant with meeting every rule of the town of Canmore. And I don't know, I shouldn't take any more of your time, but I'd be happy to answer any question if you have.
Thank you for your presentation, Ms. Boland. Are there any questions from the board? Seeing none, I just ask, are there any others speaking in opposition to the appeal today?
I have no others registered to speak in opposition of the appeal today.
Thank you. Is there any additional correspondence in opposition to the appeal that we have not received in our package?
No, there has not been anything received.
Thank you. I would now ask that those speaking neither in favor nor in opposition to the appeal come forward and make their presentation. I would ask the clerk if there are any such people registered.
I did have one that registered as neutral to the appeal, Louise Crawford, but she had already spoke prior.
Another moment.
Yes, Ms. Crawford.
Hi, I would like to just to really make it clear that yes, I was neutral. And the reason why I was, why I somehow ended up in that little speaking spot was that I really wanted to make sure that what I want to say now is that this is not being against what has happened here, what has come out, and everybody else has said that. It's that this needs to go back to the town and they need to clean out what is actually what a bed and breakfast rules are so that they can be upheld. So much work was done on those tourist homes and the vacation rentals, so clear, but it turns out that with this bed and breakfast, it's slidey, which makes it hard for the town. It makes it hard for the person who's trying to open a bed and breakfast because there isn't a clear sort of, this is what a bed and breakfast should be that is different from a tourist home, that is different from something else. And I think it's going to be really great now that we as a community actually talk to each other and go, okay, there are things that I didn't know. There's way much more now that I know now that I didn't know before. I know that came out. And that we now need to support our community. We need to support our place, McDonald Place, and come together to take care of each other and not to have acrimonious things come out of this. That's my hope. I'm thinking of the Ukraine and what's going on there. If we can't be a good neighborhood, yeah, I'm done.
Okay, thank you, Ms. Crawford, and thank you for clarifying that you're essentially neutral on this appeal. I'd just ask the clerk, is there any correspondence neither in favor nor in opposition?
No, there is not.
Thank you. I would ask the other board members if anyone desires a short recess or whether we should proceed to conclude this meeting. I'm not seeing anyone asking for a week recess. So reading now, we come to the closing remarks. And I would ask, given where we are in the day, to please keep your remarks very brief and try not to repeat any submissions that you've already made to the board. Thank you. And we'll start with the appellant. Do you have any closing remarks?
I don't really have closing remarks. I have 2 or 3 things just in response to what we've heard from the operator. First of all, the whole discussion around Airbnb, please read our written submissions carefully. I understand the difference between Airbnb as a marketing and Airbnb styled operations as a short-term rental or vacation rental. And those distinctions are clear in my written discussion, and I still feel strongly that that your board will have sufficient authority to deal with this as a short-term rental in the broadest sense of the word. Secondly, just from a factual position, the two small homes that are existing behind number 17 that the appellant mentioned, or not the appellant, the owner mentioned that she's not had any complaints from. One of those is a small home that's been sold to a developer, will be demolished, and a duplex similar to Jerry, who spoke to you, will be constructed on that lot. In all likelihood, bedroom windows will be even in greater proximity to the existing patios of the bed and breakfast. The one beside it, I don't think has been sold yet, but he's a very good friend of Pat and Kathy Sullivan. And if you wish to confirm how he feels about this and the noise impacts he had, he would be happy to tell you. I think the other thing I would like to say thirdly is the applicant quoted the Municipal Government Act to say actually and materially interfere is a standard for deciding interference with quiet enjoyment. Well, that may be the case under that act for that specific, when it was talking about your authority to make decisions. That is not the wording in our land use bylaw. It does not require us to prove our enjoyment has been materially affected. And even if it did, I suggest to you that 12 out of 17 homeowners is pretty material. And finally, we heard the word compliant over and over and over again, fully compliant, and went back to last year's subdivision and appeal board hearing as evidence of compliant. I would like to argue that that is a bit circuitous. At the time the subdivision appeal board heard this last year, we did not, all we knew was the physical layout of those suites. We had no other information about how they would be operated other than what was said in that meeting, which turned out not actually to be very accurate. So I think to go back and say that you're going to hang your hat on the compliant, being considered compliant because of last year's subdivision and appeal board hearing does not make a lot of sense, at least to us. And it related to that then is the statement that says we are not significantly different than other bed and breakfasts in town. And that's what we've proven through the course of this first year. But by saying we're not significantly different, that kind of proves our case. You are different enough that it allows the authority of this board, the subdivision and appeal board, to look at the rules, to look at the words of the bylaw and come to a different conclusion when you consider the actual facts in front of you on this case, on this file. So with that, there's been lots of discussion. I thank you so much for giving us this much of your time. It's
Can I just add? I'm sorry.
Sure,
Before I close.
go ahead.
Just one thing, a request, I guess, to the applicant and maybe her rebuttal is if she could comment whether or not there were any modifications made to the suites, say in the last 5 or 6 months in advance of the inspections that she referred to.
Okay, thank you for your closing remarks. I'd now ask the applicant if she has any closing remarks.
I do have some closing remarks, Mr. Chairman, and I'll open by answering the appellant's question. I have no idea where that question comes from. There have been no modifications to our suites from the time they were originally constructed. There have been no changes at any time since they were first inspected, since they were inspected by the B&B Association, and they were recently inspected by the town. They remain as they were originally developed, built, and furnished. The fact of the matter is that, and I think this is alluded to in the letter that we submitted with our original application, or else it's alluded to in our written submissions, but the comment the other appellant made about our suite not being significantly different from other B&Bs and turning that to say, but it is different enough. I submit it's not. we undertook a survey of other B&Bs that operated in Canmore throughout the last year, and the majority of them have private entrances that the guests use the vast majority of the time. Many of them provide breakfast food in the suite, or some of them not at all during this time, rather than cooking and having the guests eat at their table in the old style of B&B that the appellants refer to. And most of them use some additional services or employees to help them in the operation of the business. So in all of the fundamental ways that the appellants complain about, our survey revealed that those B&Bs that were still operating through COVID were not, the majority of them were not different, although there are some differences with some of them. In closing, I would just like to say this. We respect the right of our neighbors to have their own opinions about whether B&Bs should be permitted in this neighborhood and about what the policies should be. This is simply not the correct forum for them to try to affect change to those policies and to try to impose a different interpretation or application of the policies on us because our neighbors would prefer not to have a B&B on the street would be unfair to us. The policies should only be varied and changed on a global basis. I echo the comments of Ms. Poland to the effect that we too would welcome any chance to engage with the town if it wants to review what those policies are and wants to consider any possible changes to them. But this is simply not the right forum, and this board is not the right body to effectively change what the town policies are with respect to B&Bs. We also respect very much our neighbors' right to be heard at this appeal. I wish we could have engaged in conversation directly before we got here, but I respect their right to be heard at this appeal. However, their seeming suggestion or implication that their interests or their preferences about what happens on my property should take precedence over our wish to conduct this business reasonably and peaceably on our property in a manner that is compliant with the bylaw can't be correct. It can't be that this is a numbers game or that by getting names on a petition, we can be deprived of the opportunity to carry on our business on our property that is compliant with the bylaw because one or more of our neighbors would prefer that it not be so. They have not provided evidence or even cogent, clear allegations of actual interference with their right of quiet enjoyment of their homes by any reasonable definition of that term. And on that basis, we respectfully request that again this year, the SDAB confirm the renewal of our permit. And we ask and hope that our neighbors will engage with us constructively in the future and will allow us to quietly enjoy our property after the permit is issued, including continuing responsible operation of a high quality B&B operation at this location. Thank you, Mr. Chairman.
Thank you, Ms. Saunderson. At this point, I'm going to ask each of the appellant and applicant a question regarding fairness of the hearing. Does the appellant feel that they have had a fair hearing?
Absolutely. Thank you very much.
Thank you. Does the applicant feel that they have had a fair hearing?
Yes, Mr. Chair. Thank you very much.
Thank you. So this public hearing portion is now concluded.
Oh, Mr. Chair.
Sorry.
Sorry.
Yes.
I believe Marcus Henry, who's the planning supervisor.
Yes, you're correct. Sorry about that.
That's okay. Yeah. Closing remarks for admin.
Sorry, Mr. Henry. That was my oversight.
No, that is no worries. This has been, I would say, one of the most engaging discussions, and I just wanted, to have our opportunity as administration to give our closing remarks too, because this is. This has been a lengthy discussion, and I just wanted to point out that these are great discussions to have. This is the essence of community planning, right? As administration, and we don't just want to make decisions on, what we think is right. Like community planning is about engaging with the community, and like creating that community presence that we also love, right? But the one thing that I would want to point out here today is that, as you've heard before, and I just want to emphasize it from an administration perspective, is that this is not the forum to kind of make these changes onto the regulations. And one thing that I will want to drill home here is that, when we look at the intent of a land use bylaw, the intent of land use bylaw is to control and regulate use and built form, right? What I've heard a lot of today is it's around, the issues with the operation of the bed and breakfast. These are all things that when we did this last round of, or like when we were looking at the new land use bylaw, sorry. So this current bylaw that we had in place, we went through with a fine-tooth comb with our legal representatives at the time and said, what in this land use bylaw are things that, should not be in here? And one of the things that we looked at were things that, we can't enforce. Like we can't logically or practically enforce. And when we looked at this, we specifically looked at, like the bed and breakfast regulations. And for those who are not familiar with the previous regulations, one of the regulations that we had, was that you had to provide a meal. And it was like, well, how are we as planning expected to confirm this? Are we calling every morning and saying, did you provide a meal? And that's just, it's unrealistic. So when we look at the land use bylaw, we really focus it around, regulating use as in terms of where an appropriate use, can be located. And then looking at the built form. When we're looking at the built form, is it contextual with the neighborhood? Is it meeting the, existing neighborhood design and contextual elements of that, specific neighborhood? And that's what a land use bylaw is for, right? So I just want to kind of reinstate that here, that when we're looking at this application, those are the things that we as planning and as the board as well need to look at. Does the application conform with the land use bylaw? And I heard lots of issues around, well, it's not an appropriate, a use within this neighborhood. And if, that's how the community feels, I would love to hear that discussion. I would love to engage with you. The planning department would love to engage with you, and council would love to, because we want to make this place better. But through this hearing, that's not the place to kind of, just flag it and say, I don't want this in my neighborhood. I don't think it's a suitable use. There's a process for that, and we need to acknowledge that, because that's, the way that we get the whole community involved, right? Because right now, as much as I'm hearing some very, some genuine concerns, we haven't heard from the rest of the community. And that's what we want to hear, right? Right now, we're sort of having this siloed discussion in specific, to one street. So I just wanted, to emphasize that there a little bit. And I'm not going to get into repeating a lot of what we heard, because we heard a lot of content today. We did. But there are a few things that I think are worthy of noting. One in particular is the food preparation facilities. One thing I'll be first to admit, our land use bylaw is not a perfect land use bylaw by any means. And if anyone out there knows of a land use bylaw which is perfect, please let me know, because I would love to read it. But when we're looking at land use bylaw and specific to food preparation facilities, the approach that we have taken with that in planning is if you were to have a kitchen of your own, what is critical for you to be making food? And that's very important here, right? So within the definition of a dwelling unit, we make the reference to the 220 volts. The reason why we have done that, because that's, a typical component, for including something like a stove or an oven, right? And those are sort of the, main, preparation, utilities that would be used within the kitchen, right? The other ones we would consider is, a microwave, because you can easily prepare lots of meals with that. And the other one, which is sort of debatable, is the hot plate. That could also be used, right? Because you can put a pot on there. You can create meals using that. But the other side of that, which is very relevant to all of this, is that when you think about a B&B or even, a visitor recom unit, something like that, there's nothing restricting somebody from, eating food within that space. And that's not something, again, that the land use bylaw would regulate, right? We're looking at the form and whether or not that use is appropriate within that neighborhood, right? So when we look at, things like, well, is there, food preparation happening in there? It's like, well, that could be very debatable. And at the same time, something like, I don't know, I'm opening up a bag of chips and putting that in a bowl. Is that considered food preparation? So we need to think about that stuff as well, right? And what's actually regulated and controlled. And when we look at, the outside amenity spaces, that's not something that we regulate through the land use bylaw. So if somebody wants to have an amenity out there, something as simple as say like a barbecue or a fireplace or even seating, we don't regulate what goes out there. That's solely up to the discretion of the property owner, right? And that's not where we want to go with the bylaw saying you can only have, a chair or two on your patio. That's not where we want to go, or that, you can't have a barbecue within your backyard. That's not what the land use bylaw is here to do. The other thing I wanted to speak to quickly was around the parking. Again, when you're looking at the application, this application actually exceeds the parking requirement. So, in an instance where, there could be a booking which shows up with say 2 vehicles or even 3, if there is overflow onto the road, that's totally fine. Nobody owns the right to the parking on the road. That's for the public in general. No one property on the street or anybody can say you can't park there. That is open for anyone and to use. So knowing that this application meets and actually exceeds those parking requirements, from a perspective of land use bylaw and planning, we don't have an issue with that. The other thing I want to make note of is 2 more quick things here, because I don't want to repeat what everyone else has said. But we heard lots of references to the town of Banff. They have a bunch of restrictions and clarity in their regulations, and we should, be using that as a precedent. And it's no, that is really great. And I would love to dive into that further under the proper forum. Trying to apply those things now to the SDAB or this hearing, that's not really relevant here. We're in Canmore, we're not in Banff. We're not going to adopt the regulations from Banff. If we want to consider those, we have to go through the proper forum to do so. And then the last thing I just want to make note of here is around the noise complaints. What we have heard today, we heard some issues from one of the appellants, like Jerry Auld, around the noise complaints, and I am very sympathetic to that. I truly am. But this is the first we have, actually heard of these complaints. If we had, heard of these complaints, even if it was after the fact because they weren't able to reach bylaw, we would then follow up with the property owner and make sure that, we can have that discussion with them. But when we don't hear anything, it's virtually impossible for us to action anything, right? Because what we don't know, we can't action. So beyond that, I'm going to just leave it there. But, looking at our review, what we can see here in terms of what we can control and regulate through land use bylaw, this B&B conforms to land use bylaw and is no different than any other of the B&Bs that we see around town. It is very similar in very many respects. And on that note, I'll leave it there. We have taken up a lot of valuable time from everybody, and I really appreciate everyone's open and honest discussions with this. This is a great conversation to have, and I look forward to actually having more of these conversations with you. As we look to improve these regulations and make change in the community. Thanks everyone for their time.
Thanks very much, Mr. Henry. Do any board members have questions for Mr. Henry? Seeing none, I would just then just quickly ask the appellant and applicant again, do you feel you've had a fair hearing? We'll start with the appellant.
Yes.
Yes.
The applicant?
Yes.
Thank you. All right. Take a second crack at concluding this meeting. So this portion of the hearing is now concluded. And in accordance with provincial legislation, the board is required to hand down its decision within 15 days from today's date. No decision is binding until the board issues a written decision. Now, I would move to my fellow board members that we briefly go in camera to discuss the process and timing to arrive at a decision, given that the hour is quite late now. And so I would ask, oh, sorry, I should just do one more thing. Before we have a motion on going in camera, I would move that the board adjourn this public hearing of March 3, 2022. All board members in favor, please raise your hand. Motion's carried unanimously. I'll make another motion about going into in camera. I move the board go in camera. Those in favor, please raise your hands. Motion unanimously carried.